of Plascat JA, but the way it encapsulates the principle is as follows, quote, the correct approach is not to ask whether an action is prohibited or precluded by law, but whether it is permitted by law. That's the what I call the, if you like, the abiding notion in this particular application. Now, coming out of that and forgetting the legal formalism now as to whether we're dealing with review or declaratory order, section 172, and so on, that notion cuts across all those conveniences. Which then brings us back, my Lord, to, and this is where I end what I call the overview, brings us back to the question. So the burden, for lack of a better word, on the state is always for it to provide that justification to a court of law. So it's not a civil claim for damages where just because we are the applicant, we have to establish, if we don't establish our case, well, then we must go home.
But isn't it the case that for the state to justify what the state did, the claimant in turn has to establish the legal basis to what the claimant says they're entitled to?
No, of course. Of course, at least a prima facie case. So in other words, if I come and I say, well, you've locked me up in a cell, and therefore prima facie you have encroached into my right of movement, it's only then, your Lordship is quite correct, only then does the burden arise on the state to then justify. Because prima facie, obviously you have restricted my freedom of movement. But that's the slight difference between a normal case, quote unquote, and one where we're applying the Constitution. And that's why we have Section 36 of the Constitution. Because Section 36 of the Constitution, in my book, is the most important section. Because it's all very well to say, I have a right to this, a right to this, a right to that. But Section 36 says, well, there are obviously instances circumscribed by law where there is a justification, where there may be, a justification for that encroachment. So your Lordship is quite correct. It's not like the claimant just comes to court and says, okay, well, justify. The claimant has to lay a basis, and once that basis is laid, particularly when we're dealing with the Bill of Rights, once that basis has been laid, then the duty to justify arises. And in this context, it arises at the risk of repetition. It arises in this context of saying, well, there is this conduct which you have done against me, which adversely affects my rights and so on. Now you have to convince a court of law that it has some legal basis somewhere. Whether it's in a contract, whether it's in legislation, whether it's in the Constitution, whatever, but it must have some legal justification. Right. So that's the canvas, if you like. Now, when we come to the actual painting, in this particular matter, we then have to look at the interpretation of the relevant instruments, which have purportedly been relied on by the state in order to perform the impugned conduct. And then the case will really turn on to, if they are able to establish from anything in law that there is such a justification, well, then they must succeed. If they cannot provide such a justification in law, not in because of feelings or whatever, but if they can't find that justification in law, then they must lose. Now, having said all that, then, my Lord, let's get to the the nuts and bolts. And again, the advantage of your Lordship having gone through the issues here is that we can, what we really propose to do, my Lord, is to find some shortcut. This case has got all sorts of byways and freeways and alternatives and further alternatives and so on. But forget all that. Let's zoom into the proper sequence. In our respectful submission, the starting point, one can start anywhere. I'm sure all my learned friends will start at different points. But for us, my Lord, the logical starting point is section 2195 of the Constitution. Because it does two things which are important. It gives us the source of the gratuity that we're here about, but it also answers another question which is important around what is remuneration. So, as your Lordship knows, the heading in these kinds of analysis can be important. So what's the heading to 219? It says remuneration of persons holding public office. Very simple. So this entire section is about remuneration. And then the relevant portion is 2195.
Yes,
Thank you, my Lord.
yes, I'm able to follow.
You found it, my Lord? Yes.
Yes.
Right. 5 says simply, my Lord, national legislation must establish frameworks, okay, frameworks for determining the salaries, allowances, and benefits of judges, the public protector, the auditor general, and members of any commission provided in the Constitution, including the Broadcasting Authority, including the SABC. So that's, I call that the source document, because that's where the power is sourced. It says national legislation must do X, Y, Z. But the important words there, my Lord, are framework and salaries, allowances, and benefits. In other words, salaries, allowance, and benefits is what is collectively used as, or the collective noun used in that section is remuneration. In other words, remuneration covers those three subtopics. Now, and I want to take your Lordship through this journey very quickly. So, from that source legislation, you then get the Public Protector Act. So the Public Protector Act then becomes the national legislation that is referred to there. Obviously, all other national legislation, such as the Basic Conditions of Employment Act and so on, is also relevant. But it's quite clear that the primary national legislation envisaged in Section 2195 is the Public Protector Act, at least insofar as you are dealing with the Public Protector Act. When you are dealing with judges, that national legislation is the Judges Remuneration Act and so on and so on. But qua Public Protector, it's the Public Protector Act. Now, that act you'll find, my Lord, in the second bundle behind in our manual bundle. But I would refer, if your Lordship is looking for it electronically, then it's section 2, bracket 2.
I do have it, thank you.
Escort, please. Right. Section 2, bracket 2 of the Public Protector Act says, my Lord, the remuneration, here's that word again. So in other words, it flows directly from 2195. So the remuneration and other terms and conditions of employment of the public protector shall, subject to 110 of the Constitution, from time to time be determined by Parliament upon the advice of the committee, provided that such remuneration shall not be less than that of a judge of the Supreme Court of South Africa. Okay, so what do we get? So we get here that this is literally almost a carbon copy of what we said in 2195. Remuneration, determination, it shall be determined by Parliament, the same word that's used in 2195. So that this national legislation now tells us more than the Constitution is obviously just a broad framework, broad brush. This one now tells us specifically who must provide the framework referred to in 2195 in respect of a public protector, and that is Parliament. Right? Then it's common cause that what then happened is that in discharge of this duty, the National Assembly passed the service conditions. Right? So the flow chart is simple: 2195, Section 22 of the Public Protector Act, and then all that gives birth to the service conditions. Right. So,
just out of curiosity, Mr. Mpofu,
yes,
as I understand Section 22 to say that Parliament is to do the determination.
Yes.
And then the National Assembly is the one that passed the conditions of service.
That's correct.
Now, the National Assembly and Parliament are not the same thing.
Correct, my Lord. Yes, my Lord, that's true. But for the purposes of this discussion, my Lord, that distinction is not important.
Yes.
We accept, your Lordship, as your Lordship correctly points out, that Parliament properly defined means the National Assembly and the NCOP. Yes, but it's been established in some of these cases. I once had a difficult time in the Constitutional Court trying to make that point. Firstly, why the Speaker? You say, well, the Speaker is the Speaker of the National Assembly, but the Powers and Privileges Act, to the extent that it says Parliament, the
so
Speaker.
Nothing turns on that.
Yes, nothing turns on that distinction, but it is a real distinction, my Lord. And none of the parties take the point that the National Assembly's passing of those of the service conditions was not according to the empowering provision. But my Lord, be that as it may, what then happens, my Lord, is that, and the reason I'm taking your Lordship through this journey is because of as I say, the evolution or genesis of the gratuity. On the one hand, if your Lordship can then put a notional finger on that journey, and then go to the Bill of Rights. And in the Bill of Rights, your Lordship will know that we've raised a whole number of sections there. But for the purposes of this discussion, I just want to zoom into one or two, and I'll explain that. But the important one, Section 23. And the reason that I say or two is because your Lordship knows that Section 23 also encapsulates the right to dignity and so on and so on. So it's not just a bare right for fair labor practices. Now, let's just take that section. So the Constitution, now, not just the Constitution now, the Bill of Rights, fundamental rights, confer upon each one of us, including the applicant, the right to fair labor practices. Right? Now, knowing Your Lordship, I don't have to convince Your Lordship that the right to remuneration is part and parcel of that right to fair labor practices. It's obvious. Otherwise, it would be slavery. So
But you are dealing with gratuity, not remuneration. Do you draw the respondents draw a distinction between the two?
Well, my lord,
You'll get there.
Yes. That, by the way, is exactly the fundamental reason why I started at Section 2195. Because, as I say, it kills two birds with one stone. It deals with the genesis, but it also comes to the word remuneration, what it actually means. So, for current purposes, Your Lordship, assume that that I will explain later the connection between the two. All I'm simply saying for now is that the right to fair labor practices obviously encompasses compensation to that labor, to that work. And it also encompasses the right to dignity, livelihood, self-worth, all sorts of things that flow from it. But I was simply saying I want to zoom in onto that right itself. Now, that right, as Your Lordship obviously also knows, is one of those rights that are not exercisable directly. In other words, you have to exercise it through subsidiary legislation. And the normal legislation through which it is exercised is the Labour Relations Act, but that's not relevant for the current purposes. The other legislation through which it is exercised is the Basic Conditions of Employment Act, which is very relevant. My Lord, yes, okay. Well, it looks like my junior did not include it in that bundle, but Your Lordship has got it. Let me, I'll come to the specific sections. Basic Conditions of Employment Act, my Lord, you'll find the relevant portions thereof quoted in our, in our supplementary founding affidavit.
Which provision?
I think it's section 2. Sorry. Supplementary. Let me just make the point, my Lord, so that we don't waste time. I'll find it the section. Okay, it's right that the basic conditions. Okay. Yes, I'm told that documents start from 02-1, but
I do have the legislation.
Yes. or the concept of gratuity. Actually, that case was not interpreting gratuity, it was interpreting donation. What is a donation? And in the context of the donation, then because we know that one of the things about a donation is that it's given gratuitously.
Well, there is a statutory and a common law meaning of donation. That's what the case
Yes,
said.
but this is, it was dealing with the statutory one, because obviously tax law, the donation in terms of tax law is based on the statutory definition. Because for you to have the liability for donations tax, you obviously have to show that the receipt in the hands of the taxpayer was a donation. And even in the donations tax is one of those strange ones where it's taxable both in the hands of the donor and the donee. But I digress here. But the point is that the word was being defined in that context. In this context of a gratuity that is not linked to a donation but linked to employment package, for lack of a better word.
Well, Mr. Mpofu, I suppose what the court needs to know is, as far as the applicant is concerned, what does the applicant say a gratuity means?
Yes.
I mean, you are at a point where you've submitted that it falls within the category of benefit.
Yes.
But as to what it is, I understand that you'll still indicate
Yes.
the applicant's position
Yes.
to the court.
Okay. Put it this way, my lord. Again, as I say, we can do the shortcut or the long way. The shortcut is that if I'm correct that it falls under benefits, then obviously it's one of the three things defined in Section 2195 and the thing defined in the Remunerations Act, and that's how it finds itself in the service conditions. Because you see, my lord, as a matter of just pure logic, if we accept that the service conditions are, shall we say, a grandchild of Section 2195, so the parent is the Public Protector Act, and the Constitution is the grandparent, so to speak. Then we have to accept as a matter of logic that all that flows, everything that flows from that chain, which I showed to your lordship, must be, by simple logic, something that flows from the three things. So it's either an allowance or a salary or a benefit. Otherwise, why would it find itself in the service conditions? Because those service conditions are a product of that injunction.
Yeah, but you are making an assertion, Mr. Mpofu, in the submission that gratuity is embodied in the expression benefit.
Yes. Yes, I am, my lord. But I'm saying that I'm now busy demonstrating why that is so. And I'm saying that is so, okay, let me put it this way. I'm showing your lordship that to answer that question as to why that is so, one must not look into tax law or some other definition that has nothing to do with what we're busy with here.
Why would, in the case that you are pleading or making submissions on, why would a gratuity fall under benefit as opposed to, say, under salary or under, what was the third element?
Allowance.
Under allowance. So why does it follow that it has to be an extension of what the court is to understand as a meaning of benefit?
Yes. It is because, my lord, when you look at a remuneration package, remember those three things in terms of Section 2195 are constituent parts of a remuneration package, because the heading says remuneration. Then it unpacks it. In the actual text, you don't find the word remuneration. It just tells you, it unpacks it. Salary, allowance, or benefit. Now, it's deductive reasoning is that a salary is something that's defined, which is the basic salary of a person. In fact, even in the...
But you will not look to the Constitution for that. At the minimum, you will look to a statute.
Yes, my lord, of course. So when the constitutional writers put the word salary there, there's no definition section in the Constitution that says what is a salary. It assumes that, as your lordship correctly, you'll either look to a dictionary or a statute or whatever it is to understand what each of those is. But let me make an easy. Let's not talk at the theoretical level. Let's go to the actual provision. And your lordship, okay, if your lordship goes to 02-185, that's the service conditions. You'll find it at different places, but I just...
Right.
It's BMG 1, I think.
Yes.
The lordship is there. Yes, thank you. So, just to answer that question, so you have the service conditions are listed there. What is number one? Salary. So we know what the salary is. It says an annual salary at the rate equal to that of a judge of appeal of the Supreme Court of South Africa. So that's salary. And then it talks about allowances. 2 and 3, 2 and 2A, sorry, are allowances. Non-taxable allowance, entertainment allowance. And then number 3 is gratuity. Right. Now, I'm saying that this is the correct formulation, which shows what I call the parentage that I was talking about. That this document comes from Section 2195, which says the National Assembly or Parliament must give us a framework for salary, there it is, allowance, there it is, and benefits. So I'm saying that from a logical point of view, the gratuity that is set out there is clearly not part of the salary. We all know what the salary is, a basic salary, and I think it's actually defined either in the BCA or in the LRA. But a salary in everyday language, your salary, basic salary, is different from what is commonly known as quote unquote the package, which also includes all sorts of things.
I mean, what is the nature, as far as the applicant is concerned? What is the nature of the service conditions as far as the applicant is concerned? I mean,
thank you, Mala. Yes, it's common.
How does she
conceptualize it?
Yes.
Yes.
Is it term of condition, as one might understand that in a contract? Is it a statute?
Delegated legislation.
Yes. What is it?
Yes, that's a good question, my lord. You'll see that we've addressed that in the supplementary affidavit. And we say, for the purposes of this case, it doesn't really matter whether you look at it as a contractual term, and I'll explain that, or as delegated legislation as such. Because it really doesn't matter, because either way, whether it's a contract or delegated legislation, what we know is that it's subservient to the legislation, subservient
but
to the...
it will make a difference whether it's a point of contract or a point of legislation, including subsidiary legislation. As
Yes.
I understand the case, the pleaded case, the applicant says that the service conditions is what is contemplated, I'm paraphrasing, is what is contemplated in the BCEA as
the employment,
an
service
employment contract.
Yes.
So
Yes.
that seems to suggest that she says that the service conditions are part and parcel of her contract of employment.
Yes, my lord. That's common cause, by the way. It's common cause between the parties that the service conditions constitute, for current purposes, the employment contract. And there's a reason. Can I just pause and say this, my lord? Because this will become important when we talk about purpose, so that your lordship can really situate the service conditions. There's a case, I think it's called Judicial Service Commission and something. I'll get it. For your lordship, which says that these people, there's a constitutional reason, my lord, why you and I, who's working in the factory somewhere and so on, the Constitution doesn't care about how I get my salary and so on. That's a matter of contractual negotiations between me and my employer. So why has the Constitution singled out in Section 2195 judges, Auditor General, the Public Protector, and so on, for a regime through which their employment contract is defined? It's very simple, my lord. It's the notion of independence. And I'll find your lordship's, I'll find the reference to that case, which dealt with judges. And in that case, it was said that judges and those people named there should not be put in the position, like all of us, where they have to bargain for their employment contract with the executive, as it were, for obvious reasons, which have to do with independence. And therefore, the Constitution saw it fit to prescribe a method by which their quote-unquote employment contract will be determined. In the case of judges, and this whole service conditions is replete with references to judges. Salary is equal to that of a judge of appeal, a motor vehicle judge of the Supreme Court, and so on. 8.3, subsistence allowance payable to the spouse of a judge of appeal. 8.5, allowance payable to a judge of appeal. So the reason why there is this relativity between a public protector and a judge is because the underlying concept is the same, which is the concept of the independence. Otherwise, the public protector should have just gone to negotiate.
But I don't think the respondents put in issue
with
the
that.
fact that the public protector, a person holding that office, is entitled and is required to be independent.
Yes, no, my lord. Neither do I, quite frankly, knowing my learned friends. But I'm making a separate point. I'm saying that one of the, because remember, at some stage you have to look at the purpose of this. I'm saying one of the key issues under purpose is that issue of independence, and I accept your lordship. I'll take that as granted. Yeah. So it is indeed a contract of employment, my lord. But I'm trying to explain why a contract of employment, why would a constitution of a country worry itself about a contract of employment? Because it normally wouldn't, but it does so because of this notion, this underlying notion of independence. So those people are in a special category which constitutionally their employment contracts are prescribed by law, so that to save them from the, I don't want to call it embarrassment, the inconvenience or the legal separation of powers problem of having to negotiate with the with the executive. Now, so my short answer to your lordship's question is that for the purposes of this case, we look at the service conditions as the employment contract. Right. Now, but obviously, as employment contract sui generis, which flows from the flow chart that I explained earlier. Now, if you do that, my lord, then it will be easy to understand that the Basic Conditions of Employment Act applies here, because we know that the Basic Conditions of Employment Act applies to everyone except those people who are excluded from it, such as members of the intelligence services and that kind of thing. And so that's the one thing. The other thing, my lord, is that so your entitlement to remuneration as from Section 32 of the BCEA is just your entitlement like anybody else, except for the excluded people. The second important provision of the BCEA in that context is the one that says, my lord, that for all intents and purposes, the provisions of the BCEA are the minimum, that's what's called Basic Conditions of Employment, are the minimum threshold below which no contractant can sink. In other words, if the Basic Conditions of, and I'm just making a wild example, if the Basic Conditions of Employment Act says you will have 20 days leave as a human being, you can't then contract and say, you can't contract and say, no, you'll have 10 days.
Yes.
But you can contract and say you'll have 30 days. That's no problem. But if
the BCEA defines remuneration.
Yes, it does. I'm coming to that now.
Right.
I'm coming to that just now. But I'm just, I'll go immediately to that, if your lordship can just bear with me here. The point I'm making now is that the Section 4, I think, of the BCEA says a basic condition of employment, which is the same thing as a service condition, we can call it what you want, or employment contract. The label doesn't matter. But a basic condition of employment constitutes a term of any contract of employment. We've now established that that's what we're dealing with here. Except to the extent that a term of the contract or employment is more favorable to the employee than the basic conditions of employment. So in simple language, that means what I was just saying. You can't contract for something less than what the BCEA gives all and sundry. Now, if your lordship goes to, sorry, if your Lordship goes to the 02-1, sorry, my Lord, yes, -5. Oh, okay. I see where the confusion is, because of some historical reasons there were 2 supplementary affidavits. Sorry, my Lord. The definition of no, the first one. The definition of remuneration, my Lord, is not something really esoteric. It actually covers the same ground as its quote-unquote definition in the Constitution.
Except there is no mention of gratuity in the BCEA.
Yes, madam. And there's no mention of car allowance. There's no mention of transport allowance and so on.
Just bear with me. In context, the minister, sometime in the past, published a determination in terms of this act, in terms of Section 35(5).
Yes, ma'am.
And I will read it to you as to what it says. The Minister of Labour has determined in Government Notice 691, dated 23 May 2003, that
691, my Lord.
691, dated 23rd May 2003, that the following method of calculating employees' remuneration for the purposes of annual leave in Section 21, payment instead of notice in terms of Section 38, and severance pay in terms of Section 41 of the Basic Conditions of Employment Act shall be effective from the 1st of July 2003.
Right.
And then what I wish to draw your attention to are the following. In that determination, in Section 1 or Item 1, it reads as follows. The following payments are included in an employee's remuneration for the purposes of calculating pay for the annual leave in terms of Section 21. Payment instead of notice in terms of Section 8, and severance pay in terms of Section 41. And then for what I wish to you to comment on is Item 2. Then it says, the following items do not form part of remuneration for purposes of these calculations. And in sub C, it says gratuities, in parentheses, for example, tips received from customers and gifts from the employer. So a distinction seems to be made there as between what constitutes remuneration and how that relates to gratuities.
Yes, my Lord. My Lord, you see, that's exactly the point I was making about taking a word out of its context. So surely, nobody is going to argue that the gratuity that is prescribed here from the statute or sub-statute or whatever you call it is equivalent to a tip given to someone in a restaurant.
Well,
both
forgive me, I read this to mean that a tip is an illustration, but the point of substance is gratuity.
Yes, but that's the point, my Lord. I'm saying if you accept that that's an illustration, it should at least tell you one thing, that there are gratuities and there are gratuities, and that one of them falls under the tip, which is why that is given in that notice. But I'm saying that and another gratuity might be the one to do with donations tax. But I'm saying the gratuity in relation to a term, a contractual term, where there is a prescribed formula cannot be equated to a tip. That's the point. So in other words, that's what your Lordship has just read exactly shows that there are, what shall we call it, categories of gratuities, starting from the mundane to the legislated serious type. That's exactly the point that that demonstrates. Now I'm saying, let's come back here and leave the restaurant to in the current context, my lord. I'm saying that the gratuity that we are talking about is the same as that of a judge, right? Now, and so so I could be.
I think you mean to say that, as in the person who holds the position of judge,
yes,
a person holding the position of public protector also is entitled
to a similar kind of
to a gratuity.
Yes, which is not a tip. I'm saying that it's more akin. If you had two gratuities, one is a tip and the other one is a judge's salary. The one that is more akin to what we're discussing in this case is the one of the judge. That's the only point I'm making. So and why do I say that, my lord? I say that because, remember, the real underlying submission of the other side is that this is a discretionary, as I said, benevolent thing that you do if you like and you don't do if you don't like. There's no legal obligation. Your Lordship correctly characterized. That's really the submission. It's so. Now I want to demonstrate to your Lordship that the gratuity we are talking about here actually carries a legal obligation, right? So let's go to page 6 of the manual, the second manual bundle, the one underneath, the one with statutes. Thank you, my lord. So you look there, section 6, which is the key. That's the gratuity giving section of the Judges' Remuneration and Conditions of Employment Act. Again, this just that heading to tell you something. Remuneration and Conditions of Employment Act. So it's, if you like, it's the basic Conditions of Employment Act, but for judges, tailored for judges.
So, Mr. Mpofu, isn't the heart of the dispute between the parties that as far as the applicant is concerned, mm-hmm. and insofar as a person who holds or held an office of public protector might be entitled to a gratuity, that in relation to the applicant, she's not entitled to a gratuity?
Yes, my lord, if you let, I'm going to come to that, my lord. If that's the heart of the case, then I'm glad, because that's probably the simplest part of this case, and I'll come to it, I promise, my lord. Yeah, just now. But for now, I simply have to demonstrate that, you see now, that's a shift. It's one thing to say a gratuity per se does not provide a legal entitlement. It's quite another to say, even if it does, she, because of ABCD, is not entitled. And there's a subtle difference between those two, and I'm going to address it because it actually is a very important point in relation to the reasons that were given for the conduct, for the impugned conduct. If your lordship can just, with your permission, just let me finish this point. I was saying, my lord, if you look at section 6 of the Judges' Remuneration and Conditions of Employment Act, which is more akin to what we're talking about, you'll see that, and actually answers your Lordship's earlier point about the difference between the salary and the gratuity. Section 6.1 says, subject to the provisions of whatever, any constitutional court judge or judge who on or after a fixed date was or discharged from active service in terms of section 3 or 4 shall, underline shall. And then, in addition to any salary payable, that covers the earlier point, to him or her, in terms of section 5, be paid a gratuity which shall, in respect of every office held by him or her in a permanent capacity during his or her service, be calculated in accordance with the formula D times 2 times E over 15. So you have exactly the mirror image. Not only do you find this mirroring in the service conditions, but here it's concretized. Where now, if you can say, here's a statute, section 6, which says something shall be paid, and if anyone could equate that to a restaurant tip, then it means that the force, it doesn't even say may, it says it shall be paid. So in other words, it creates a peremptory obligation. You'll find the same wording if you go to the service conditions. In 3.2, which the other side wants to use.
Except there will be a distinction between the service conditions and the legislation that you just pointed out. One being legislation, one instrument being legislation, and the other instrument, as I understand, being an aspect to a contract of employment.
Well, my lord, with greatest respect, that's a distinction. What we're busy with now is to unpack the concept of gratuity. Whether it appears, your lordship said it doesn't appear in the Constitution, which is correct. I'm simply showing your lordship that the concept of gratuity, when it comes to this area of law, and those people who are all envisaged in section 2195, surely can be variable, or at least if it's variable, it can be varied by the fact that one is found in subordinate legislation or a contract, the other one found.
There might be consequences as to where one finds the
word.
For present purposes, the reference, because if it's in a statute, it might have certain consequences.
Yes.
If it's a matter of contract, it may well have certain consequences.
Maybe let me put it this way to make it easier, my lord. When the service conditions say that you will receive this and that in the same way as a judge, right? Surely, what it means is in the same way as a judge. It might mean in the same way as a judge, and as you will find it in the Judges Remuneration Act. So the two things really, they are already combined by what I've called the mirroring effect. So when you interpret a piece of legislation, you do it holistically. So one of the things that is abiding, and I've shown about 6 or 7 places, where in such service conditions there's cross-referencing to a judge, whether it's a judge of appeal or a judge of... Surely that must mean that the drafters are inviting us to create that congruence. But it can be...
Forgive me.
Sorry.
But then isn't there a distinction, some distinction between interpreting a clause in a contract and interpreting a provision from a statute?
No, not really, my lord. Obviously, the interpretation of a will, the interpretation of a statute, the interpretation of a contract have different rules and presumptions. But the exercise of interpretation itself is the same, as explained in endumeni. Any legal instrument, whether that endumeni specifically says any legal instrument must be interpreted according to these rules. Whether that legal instrument is a government gazette or a contract or a constitution or whatever, the interpretational philosophy is the same. So you can't say, well, when you interpret a contract and it says you will be given a monthly salary of X, it's different than if a statute says the same thing. It's or if a constitution says the same thing, or a will, or whatever it is. Now, if we stay true to the basic rules of interpretation of any legal instrument, then we have to, and I think it's paragraph 18 of Endumeni, it's well known. I don't have to quote your lordship, to quote that to your lordship. The point I was simply making, my lord, is actually a crucial one, in that unless if we are really going to be finding distinctions where there are not, not only where they are not, but where the lawgiver, in whatever guise, is actually telling us that these two things are akin or alike.
Except, can the service conditions be equated to what the lawgiver stated? I mean, on the face of it, that doesn't seem to be an equivalence. One being a function of contractual provision and the other being a function of what the Parliament might have said.
Yes, but all of them come from the Parliament. This one simply happens to come from the Parliament directly in the form of legislation. The other one comes from the same Parliament as a determination which is instructed by the Constitution. What can be the difference between those two things? Section 2.2 of the Public Protector Act might well have contained those conditions, and then we would suddenly say now it's the same. But it's clear that the service conditions flow from Section 2.2, which flows from the Constitution. So I can't, with the greatest respect, my lord, see any distinction between a product of Parliament that happens to be called, for practical purposes, legislation, and a product of Parliament, for the purposes that we are busy with today, and a product of Parliament, all flowing from Section 2195. Remember, all this what I'm reading here also comes from Section 219.
Well, ultimately, all law derives from the Constitution in one way or another.
No, my lord. Yes, that is true. That's not what I'm talking about. I'm saying Section 219 of the Constitution, not the Constitution in general terms. Section 219 of the Constitution says that there shall be national legislation which deals with judges, public protector, auditor general, literally in one breath, right? And then I'm saying, flowing from that, you then get, through another system, the service conditions, through another system, the Remuneration and Conditions Act. But the parentage of these two instruments is in Section 219 of the Constitution.
Yes. So
that's indisputable.
I understand the submission to be
yes.
that the service conditions, where it deals with gratuity, is to be equated to Section 6 of the Judges Remuneration Act, where it deals with gratuity.
Yes.
I mean, that seems to be the substance of your submission.
Yes, I suppose you can say that, but that's not the real point. The point that they can be equated is clear from the wording of the service conditions. The point I'm making is that the brand of gratuity that is envisaged in Section 6 of the Judges Remuneration Act, although it is still called a gratuity, create a legal right, right? Indicated by the use of the word shall. So it doesn't say that judge must get that gratuity if he behaves well, or if he churns out judgments that are like in a CJ or whatever. It simply says that the gratuity shall be paid, and that's it. So anyone who can argue that that gratuity does not create at least a legal obligation, let me put it the other way around, a legal obligation on the state, which then has a corresponding legal right on the part of the judge, will be really now gilding the lily. Now, if you go to, and that's where I was when your lordship stopped me. It was yes. If you go back to 02-185, that's where the conditions are. Yes, ma'am. You'll find that the wording, which is similar to the one that I've just read from the Judges Remuneration Act, is best illustrated at 3.2, clause 3.2, which says the surviving spouse of the public protector who died before his or her term of office has expired shall be paid an amount equal to the amount of gratuity which would in terms of 3.1 and so on and so on. In other words, in the same way as the judge's remuneration gratuity is a legal obligation, so is this one. And my lord, the point is really this, that remember, I'm still going to address your lordship on the alternative submission that the thing about the legal right or legal obligation is actually not even so central to this case, because it may well be a legitimate expectation, but we'll deal with that when we deal with the review. But for the current purposes, for the declaratory order, which is the declaration of constitutional inconsistency, it's important to establish the legal right. So that's the basis of the legal right. It's the genesis, it's the similarity with the judge's dispensation, and you'll find that from the employment of the words shall be paid, which doesn't suggest a discretionary payment. Now, if your lordship then accepts that from those in the KI, there's no magic silver bullet that says, oh, you just see the word gratuity and then you say, oh, well, that means it's a tip. It's the context, and that's why when we do interpretation, we have to look at the language, shall, that's the language. We look at the context, the independence, reinforcing mechanism of the clause, and the purpose, which is to shield the people mentioned in 2195 from. So if you have to import anything really into the 3.1, given 3.2, it would be something, that clause should read something like that. On vacation of office, the public protector shall be paid a gratuity calculated in accordance with the formula, and the words I've added in parentheses is shall be paid, as taken from the Judges Remuneration Act and from 3.2. Right. So there can never be any doubt as to the legal obligation that is created. Now, the other thing that they say, my lord, is that gratuity in 3.2 somehow assists the case of the respondents. And if I may pause, my lords, just to say that, remember what we are busy with here. We're busy trying to find the source of the power that the respondents have exercised to deny the public protector payment of a gratuity. Well, I can say without fear of contradiction, you will never find such a source. But so what we then have to do, in line with what your Lordship correctly said earlier, is to establish the source of the entitlement, so that the obligation for them to show you the source of their justification can arise. And I've now established, my lord, that the source is the primary source is the service conditions, given the context that I've painted. So one of the quote-unquote defenses is that 3.2 is proof that vacation of office only refers to a voluntary vacation. And maybe in parentheses, let me say that we are going to argue, my lord, that the word vacation of office, as used in this context, is a neutral term to which various adjectives can be added depending on what you're dealing with. In other words, you may have a vacation that results from the fluxion of time, and that's if you finish your contract. You may have a vacation that arises from a resignation. You may have a vacation that arises from the removal or the termination of contract, which is involuntary. You may even have a vacation that arises of office that arises from death, which is involuntary, unless if it's suicide. So the word vacation of office itself is a, if you like, colorless description. And what the other side wants to do is to ascribe to it some fault-based test or issues of moral turpitude and those kinds of things, which are nowhere here.
Forgive me. If the word is colorless, what is one to make of clause 3 referencing vacating office and clause 8.11 referencing
Yes.
there are three elements.
Yes.
Clause 3 has got two elements, which is 3.1, which is vacate, and then 3.2, which is death. Clause 8.11 has got three elements, the two mentioned in 3.1, and a third element, which is removal from office.
Yes. Okay, yes, my lord. Let's do it systematically. Let's start with 3.2. I'll show that both of those clauses, my lord, do not assist the case of the other side. And okay, let me not go back there. And you, it's not done like that. So you can't say my source of power to deny you your constitutional rights come from some, I don't know what to call it, not even an omission. They come from something that's not said in any piece of law, but is a cut and paste type of jigsaw puzzle combination of this and that. But let me show you that even the pieces of the jigsaw puzzle don't fit. Let's start with 3.2. 3.2, my lord, the I think it's the speaker, they completely misread 3.2 to mean that mean that upon death there is some difference. I'll find the passage. 3.2 is for just for referencing my lord. I'll call it the Ubuntu clause. That's what 3.2 is. 3.2 does this, and it does nothing more than this. It does none of the things that the respondents say it does. 3.2 says on vacation you'll get X amount, as in 3.1. But if that vacation is in the form of death, then there are special compassionate considerations. And that compassionate consideration is that if it's about death, there is a presumption or a deeming provision that you have worked for a minimum of 4 years. Right? Let me unpack that. So what it means is that if you vacate through death, even if you have only worked 1 year, the formula will be benevolently re-engineered, let me put it that way, to deem that you have worked for a minimum of 4 years. So that's just a gesture. So far from 3.2 proving what they're saying it proves the exact opposite, which is that one of the methods by which that vacation could happen is death. But in that case, certain additional rules will apply. Let's read it together. It says, the surviving spouse of the public protector who died before his or her term of the office as public protector has expired shall be paid, we've already dealt with that, an amount equal to the amount of the gratuity which would, in terms of 3.1, have been payable to the public protector had she or not died, but on a date of his or her death, vacated his or her office in terms of that paragraph. And here's the important part, is the proviso. Provided that factor E in the formula referred to in paragraph 3.1 shall be deemed to be no less than 4. Now, in simple English, what that means is that factor E is the years of service. In the case of death, there's a deeming provision which says that every time a person dies, it will not. So if you die after 5 years, well, the factor E will be 5. If you die after 4, it will be 4. But if it's 3, 2, 1, then it will be deemed to be 4. That's all. So in that brand of vacation. But what that shows is that the infusion, the artificial infusion of the element of voluntariness into vacation is with the greatest respect contrived, because it's obvious that death is what I call, it's one of the other brands of involuntary vacation. Right. So let's go to 8.11.
But why didn't the National Assembly, when it drew clause 3, why didn't they expressly mention removal from office? Why didn't they include it there?
Yes. No, that's
if there's to be no distinction between.
Yes. No, the answer is very simple, my lord. Firstly, let's start with the why did they put 3.2, which deals with death, if death is not part of what's envisaged in 3.1. That obviously wouldn't make sense, just a logical sense at all. So then let's come to your. So in other words, unless we wouldn't know if there wasn't that proviso, that kind-hearted proviso in 3.2 to introduce the deeming provision, we wouldn't know that death is included in vacation. We know it simply because it's put there. Similarly, to come to your Lordship's question, other types of vacation, resignation is not mentioned there. So one can say, well, why did the National Assembly not tell us that resignation...
Isn't that dealt with in the Act itself?
Yes, it is, but I'm explaining why in clause 3, the types of vacation of office with which the term vacation of office is pregnant are not all listed. I thought that was the question. So I'm saying that the reason why a resignation is not mentioned, as just as an example, is because it is understood to be contained, if you like, in the word vacation itself. But here's the direct answer to your Lordship. Obviously, in the case of a resignation or removal from office, the formula in 3.1 is applied as it is. So there was no need. If there was, let's say, for argument's sake, it was saying if it's a resignation, the factor E will be 3. Then it would have been explained here. And if it's a removal, factor E will be 0.5 or whatever it is. Then it would be put here. But it's obvious from interpretational rules that the absence of a similar clause like 3.2 in relation to resignations or removals is because they are governed by 3.1. In other words, E will be E. So if a public protector has been removed in year 6, it will be 6. There's no dimming provision. Same as in a resignation. It's only in the Ubuntu special provision of a death that you get some favorable regime. That's the only reason. So that's so we must break this logically in 2 steps. The first step is to disavow the notion that vacation only attaches to voluntary vacation. That's proven by 3.2. The second one is to explain, as your Lordship correctly asked, why those things that are not written there are not written. And the answer is that because they are all governed by the formula in 3.1. Now, let's go to 8.11. Now, here, what you are told is that on a completely separate thing to do with transporting your effects and that kind of thing, it shows that the drafters of this thing, of the service conditions, created a distinction. Remember, we've already just shown in 3.2 that those 3 things, vacation and death of the public protector, are already covered. So first, that theory is already blown out. But let's come to the issue of removal. You see, a removal is a trigger. And I think that's what is not understood. The office, a removal from office, is not itself equal to the termination of the employment contract. Let me explain that. It is a sine qua non, obviously, But there are two juridical, and sorry, in our heads, that word is put as judicial. It should say juridical. There are two juridical acts, right? Or three, actually. The first juridical act is the 2/3 vote in Parliament. Let's call that the first trigger. The second juridical act is a removal by the President. Let's call that trigger 2. And then the third juridical act is the termination of the employment contract. Right? Now, those three things are obviously seamlessly related, but we have to be able logically to distill them as juridical acts, by the way, by different players. And not just roll them into one thing, as the respondents want us to believe. So, a removal per se is not, it has no automatic bearing on the third leg of the series of juridical acts. So what the drafters here are doing is simply to show that whichever way the termination of your contract has arisen, and they might as well, given what I've said earlier, put the word there under Roman 2, voluntary vacation. That if it's a voluntary vacation, or if it's an involuntary vacation, such as the one caused by death, or another involuntary vacation, such as one caused by the removal from office, then this is what happens. So maybe let me explain it like this, my lord. I'm saying the same thing, but I'm doing it for emphasis. Death itself is not the termination of the contract. Death is a trigger which leads to the termination of the contract. Similarly, the removal is a trigger that leads to the termination of the contract. So that is clearly what is intended in 8.11, to say that when there's a termination, they might have even just used the word termination and forget about putting these three things. It would have had the same effect. Whether it comes as a result of any of those three things, bearing in mind what we've said in 3.2, really makes no difference.
If there is no distinction to be drawn as between removal from office and vacation of office, why then would the National Assembly reference removal from office in 8.11 if removal from office is subsumed on your submission? Subsumed meaning it forms part of vacation of office.
Yes, it's what is known in the classical interpretation rules as tautology. In other words, it happens sometimes that the the lawgiver or the drafter of a contract, or for various reasons, normally emphasis or sometimes
but
even...
That doesn't seem to apply here, Mr. Mpofu, because the Constitution contemplates removal of a public protector from office,
yes,
through the Section 194 process.
Yes.
So on the face of it, given that the conditions of service are in relation to a public protector, it doesn't strike me that the expression removal from office is tautologous.
Well, it is. And let me explain, my lord. I don't want to go back to, just as in 3.2 we've demonstrated that the word vacation, as it is put in 3.1, also subsumes death. But these people in 8.11 still put death as a separate category. That's clearly tautologous. Because if you accept that the interpretation of 3.2 yields no other logical outcome than the fact that death is a form of vacation, then surely 8.11 to that extent is tautologous, right? So 8.11 cannot be tautologous only in relation to death. Again, let me ask the question rhetorically, I hope. Does this then mean, because resignation is not listed in those three things, that if you resigned, your transportation, your furniture will not be removed? Surely not. What all that it means is that the now imagine if there was a case like that where someone says, no, you can only get your transport of your things if you die, or if you resign, or if you have been removed. But if you resign, which is a fault-free thing, you won't. You know,
but
interpretation.
But there are consequences to where a person resigns. For example, where a judge resigns his office, a judge forgoes the benefits of that office. So there are consequences.
No, that's not true, my lord. If you go to the Act...
For example, a judge who resigns his office is not entitled to a gratuity.
Well, you'll see, my lord, if you go to... page 8 of the manual bundle.
Yes.
Talks about resignation of constitutional court judges and judges from office in certain circumstances. Section 11. And it says in subsection 5, that judge must be paid. A constitutional court judge referred to in section 4, that does not apply in respect of him or her, must, legal obligation, be paid, A, salary in accordance with the provisions of section 5 and so on, B, a gratuity in accordance with the formula set out in 6.1. In other words, when a judge resigns, he or she is entitled not only to their salary but to the gratuity. Now, I'm saying the absurd interpretation which seeks to be imported into 8.11 here is that, unlike a judge, when the person resigns, really, which probably is the most innocent thing that anyone can do, resigns because of this and the other, they are relocating to another, they must be punished by being told that well, because you resigned, your furniture is not going to be transported. I mean, if there's ever an absurdity, it must be that one, my lord. And your lordship knows that there's a presumption in law that you may not interpret statutes or any legal instruments so as to produce a glaring absurdity. Now, the simple point is really this, that firstly I'm saying the tautology is glaring, it hits you in the face. But in any event, we have sorry, my lord. There are many cases. I'll give you a lordship maybe later or tomorrow. Other cases, but we've made Let me go to paragraph 68 of our heads, my lord. which your Lordship will find at 19-40.
Yes.
So I'm now busy with the second part of, no, the third, yeah. Remember that those 10 things that we suggest in our, which is really the heart of the case. The 10 issues from page 18 to 26 of our heads, where we list. So I'm now at number 3. I've explained vacate. We've dealt with gratuity, which your Lordship asked what do we mean by gratuity. So you'll find that in paragraph 58. We say gratuity is defined in the Cambridge Dictionary as, quote, a large amount of money given to someone on leaving the job. And in the other thing of local government, it says payment for service. And with the judges, it says payment for active service. So that's the only adjective that's put. And so it doesn't have the turpitude. Yeah. But now, so we're now at number 3, which is 8.11. So we say that the respondent seeks to manipulate the meaning of 8.11 of the conditions to create an artificial distinction between the related items of vacation of office, removal from office, and or death, all of which would similarly lead to the requisite termination of employment, point I've just made, and all of which would similarly give rise to an entitlement to free transportation of his or her personal effects of those of the surviving spouse. This contrivance cannot be sustained. It is indeed possible that the repetition used by the drafters in the list contained in clause 8.11 was meant for clarity and emphasis and done ex abundante cautela, without necessarily signifying tautologous or superfluous language. In the circumstances, different signifiers can be construed to mean the same thing. It has been said before that, quote, tautology and surplusage is not very uncommon in legislation. There are several cases that have made this point. Your Lordship would know them. But we've just given, sorry, at the bottom of that thing, it's instead of 952, it should be 1952. R versus Simmons is just one of the cases. But there's a plethora of cases that indicate that tautology is often found. But here the context and what I've just explained about designation makes it clear that this is one of those instances. So that's the end of the what you call it, the textual analysis of 3.1, 3.2, and 8.11. But let's come to the heart of the case, my lord. The heart of the case is this. Again, let's remember that we are dealing with administrative law, stroke constitutional law concepts and the culture of justification and all that. One of the key principles, my lord, which I really want to spend a few minutes on, I know your lordship, the time for the break.
No, you may proceed.
Yes. Maybe I'll just introduce it and then expand on it later. Is the issue of the reasons that are given for a decision. Remember, part of the justification culture and the impositions that you have on an organ of state is that they must give you reasons for a decision. Now, that's not just for decoration. It is because our courts have said that in the context of the culture of justification, an organ of state must be held to the reasons that it has given. Because if it is not, my lord, a court or an applicant for that matter can be hoodwinked ad nauseum. Today it will be this reason, And then tomorrow, if you don't like that one, I've got another one in my back pocket. And if you don't like that one, well, I've got another one at home, and so on and so on. That is frowned. No, well, frowned is an understatement. That is prohibited. That is why, my Lord, the issue of reasons is so crucial. You'll find it both in Paja. You'll find it in the legality.
Yes, I don't believe the respondents take issue with the obligation to give reasons.
No, I'm sure they don't, my Lord. But what I'm driving at is this. Our case law, my Lord, which you'll find at least, I think, 2 or 3 cases referring to this in the new bundle. Is that, and this is what was said in one of those cases. I'll refer your cases your Lordship to other cases after the break. But one of the first cases to deal with this was National Lotteries Board versus South African Education and Environment Project, 2012-4 SA 504 SCA. Judgment of Kashalia J.A. And it says the High Court dismissed the new ground on another basis. Quote, "It was impermissible," the learned judge said, "for the board to rely on new reasons for the first time in its answering affidavit." And that's what I'm saying has happened here. And then it goes on at paragraph, that was paragraph 24, my Lord. Then 26, the question here is not whether there were other reasons in the record that justify the board's decision, but whether it could give reasons other than those it gave initially for refusing the application. And then at paragraph 28, it says, this is the crux, and this is the part that's been quoted in other cases. For in truth, in truth, the later reasons are not the true reasons for the decision, but rather, this is the important part, an ex post facto rationalization of a bad decision. So that's what you have here, my Lord. You have an ex post facto rationalization of a bad decision. And to the extent that in national lotteries, that concept was introduced, and I won't read this one, I'll just give you the references, my Lord. Umgeni Water versus Sembcorp, SEMBCORP, Caesar Water, 2020, that's the most recent one, 2020 bracket 2 SA 450 SCA. So a judgment, I think, of Wallace J.A., yes. Wallace J.A. And it says at paragraph 52, the appellants are, however, bound by the original reasons given for their decision. They cannot now rely upon the management scheme as a further reason to engage in, quote, ex post facto rationalization of a bad decision, using and then the reference national lotteries. As such, the rationale contained in the explanation of the new management scheme cannot be relied on, and it must be taken as playing no part. There are many other cases, but I think your Lordship gets the point. Now, why am I saying this before we break? Your Lordship must look very carefully at what has brought us here. What has brought us here is the document at 02-233. And every time we've asked the respondents for reasons, they say, well, but you know the reasons. They are in our letter dated February 2024. That was the excuse they gave for not giving us the reasons in terms of Rule 53, and you'll find that in the answering affidavit. They say they don't know why we complain about not being given. Well, we complain about two things. We said there's an insufficient record and no reasons. They explain the records part, but they say as far as the reasons are concerned, our complaint is unjustified because the reasons are here. So let's look at that document. So you'll see, my lord, that in that document, the reasons given, well, there's one reason really, but it can be split up into small parts, but it's the same reason. It says, your client, remember, this was after trying to draw water from a stone. This is February 2024. We had been asking for these reasons and explanations since for 4 months or 6 months before. It says, your client did not vacate office of her own volition, right? So that's the only reason. And if you want to be kind, you say a sub-reason or an explanation of that same reason is that apart from the conditions of service, there's no other authority that our client is aware of, the rule of law, including the Constitution as well, the Public Protector Act, which permits our clients to consider paying your client a gratuity under circumstances where an incumbent is removed from office. It's the same reason. So in other words, because you didn't live of your own volition, and now they explain it because you are removed, the discussion that we just had. Then the last part is paragraph 3. There's no enabling provision in the conditions which authorizes, so at least they understand the rule of law, the payment of a gratuity as provided in paragraph 2.1 of the conditions in terms of ends by virtue of his or her removal by the president in terms of 194. Full stop. That's all. Now, when some hopefully clever lawyer then realized the absurdity of this, then in the answering affidavit we find a new version. The new version is now that, no, it's not the removal that invalidates or disqualifies you, as it has been said here. It's now a new thing called, it's a removal, if that removal is for misconduct and incompetence. Why did they...
How is that not the same as in the letter the applicant being told that she didn't vacate of her own volition?
Okay, my lord. It's like saying, okay, you, of your own volition. It would be like saying to a spouse, you cannot get the gratuity because your spouse died. That would be the same. In other words, they did not vacate of their own volition, but they died. And that's completely absurd. But anyway, and that would offend directly against the provisions of Clause 3. But my lord, surely, your lordship would know that there's a big difference between saying you are disqualified by a removal per se in terms of 194, right? And saying you are disqualified because of a particular category of removal. How can those two things be the same? So you can't, in the answering affidavit, introduce a new reason which was not specified when you gave the reasons. That's what the SCA has said repeatedly. But here's the best illustration of that absurdity, my lord. And that's why I call it clever lawyering, but unfortunately too late. It is because somebody must have realized that these reasons are invalid, unsustainable, irrational, all the things that we say about them, arbitrary, and so on and so on. Why? Because, and that answers your Lordship's question, how is it different? Go to section 194 of the Constitution, my Lord. Got it? No, I've got it.
(194).
194, my Lord. 194(1)(a).
Yes.
Yes. So it says these are you may be removed for 3 things: misconduct, incapacity, or incompetence. So it got home to them that a removal, that this is nonsensical, what is said in 02-233, because there might be a removal which is based on incapacity. And no one in their right mind, and I'm sure not my learned friends, as I know them, is going to argue that a removal as a result of incapacity, which is another colorless or faultless removal, disqualifies you, A, from the gratuity, and B, from having your transport, your furniture transported. I mean, that's just, if they're going to argue that, well, we'll deal with it in reply. So this is the largest sign of the absurdity inherently contained in the binding reasons from which you may not suddenly depart when you realize that they are irrational in this so-called interpretation. Because you see, the issue, the reason why they now, and the definition of arbitrariness is this. It's when you say, okay, I'm doing this because of this, and then you say, oh, well, but this, and they say, oh, okay, then it's this, if you don't like that one. And then on Wednesday, no, it's
I don't quite follow, Mr. Mpofu.
Yes.
I don't quite follow.
Sorry, my Lord.
I don't quite follow the submission.
All right. This thing called arbitrariness, my Lord, is one of its manifestations is what Wallace J.A. and Kachalya J.A. Were warning us against. Ex post facto rationalization of a decision.
Yes, no, I understood there,
Yes.
but I thought you were demonstrating to the court that aspect to an ex post facto
Yes.
rationalization. That's the context to my saying that I didn't quite follow.
Yes. No. Let me. I'll assist your Lordship. I'm saying, my Lord, apart from it being prohibited by the SCA for the reasons that I've explained, it's also a badge of arbitrariness. In other words, it also or let me put it this way: one of the reasons why it's prohibited is because it would then allow a person to change with every day that passes their reason, which is a classical example of arbitrariness or irrationality, at least. So the submission is simply this: that to the extent that this new fault-based what do you call it? Forfeiture clause is sought to be introduced. It is based on a straw man. Its foundation is fallacious. Because if indeed, as it said in 02-233, the mere removal from office for whatever reason was the reason why the decision was taken, which they are bound by, then that is ipso facto irrational, because it's absurd, it doesn't make sense, and it would introduce a punitive forfeiture clause in a situation where obviously none is called for.
Do I understand the submission to be that when the applicant was sent the letter in 233, it said what it says, whereas in the answering affidavit, a different account is given as to why she's not been paid the gratuity. Is that the submission that's been made?
No. Well, that's part of it, yes. That's the first part. But, sorry, my lord, the reason why, the real submission is not that, my lord. The real submission is that that difference has two legal implications. One is that the new reason, quote unquote, introduced in the answering affidavit cannot be entertained, as Kachalia J.A. put it, and Wallace J.A. and somebody else. I've got that. It's in the bundle, but I'm just trying to move. So that's the first. But I'm now busy introducing a second reason why that is a signal of irrationality in any event. And I'm saying that that introduction of the new reason in the answering affidavit is a typical example of what the law says should not be done, which is to change according to the weather. So I can say, no, I did this because because you are a man. And then if you show that no, but it's unfair because you also did it to so-and-so who's also a man, then say no, because you are an elderly man, and so on. And so you can move forever until you get to what this is which is a sobukwe clause. So a clause that is now directed, it will go on until you say, if your name is Busisiwe Mkhwebane, then you are disqualified. Because every time you show that this one is absurd, you come with a new one. This one is absurd, you come with a new one, and so on. That's the proposition that I'm making. And our law, unlike the apartheid laws, does not allow a situation of a sobukwe clause where you can legislate gradually until you find the person you want.
Yes. I take Mr. Mpofu that if your submission is established, the respondents will accept what the authorities say the law is.
Yes, they have to, and the court is bound by that proposition anyway. But your lordship is quite correct. The only refuge really would be to try and I don't know how, but to demonstrate that these reasons are the same as the ones that are in the answering affidavit, which is an impossible task. But if we are correct, as we obviously are, that the absurdity must have been spotted, and then the new qualification introduced for the first time in the answering affidavit. The principle is this, my lord, the reason that you give subsequently cannot be the reason that you used at the time. Remember, the reason is about the time when you were making the decision. So the new reason which you introduce 10 years later cannot conceivably be the reason you used at the time of the decision, which is what the court is interested in. Court is not interested in your new flowery things. It's interested in what was motivating you at that point.
What do you submit? I follow the broad tenor of the submission, that there's been a change in your submission. There's been a change in the justification, and that is not permitted in law.
A fundamental change, yes. Yes. And I'm telling your lordship why that change is there. It's because if there hadn't been that change, we probably wouldn't be here, or I would have finished at 10:30, because I would simply have said, my Lord, I would have stood up and said, my Lord, these reasons given here about the removal cannot hold logically or rationally, because it would also encapsulate removal by incapacity, and I would sit down, and that would be it. The irrationality would be so glaring. So to cure that glaring irrationality, this contrivance of introducing a new reason has been manufactured.
When you submit that the response is irrational, are you now making submissions on the review aspect to the conduct? I'm still trying to contextualize the submission.
Okay. Like I said in the morning, my Lord, these labels are just labels. The point of the matter is that a breach of the rule of law. Rule of law is contained in Section 1 of the Constitution as one of the foundational principles of the law. Now, a breach of the rule of law, it doesn't matter how you categorize it. If you like, you can come to a court of law and simply say, I remember Section 172 says, if you can show that something is inconsistent with the Constitution, then the court must declare it to be so. So we could have just come here and say one thing only. Say, my Lord, we've come to tell you here that there was a breach of Section 1 of the Constitution in this and that fashion, and sit down. And if we establish that, Your Lordship would have no option but under Section 172 1A to declare that is so. But similarly, as Your Lordship now points out, if you wanted to approach the matter under the alternative relief of the review, you can say one of the grounds of review is irrationality or so it doesn't really matter.
Yeah, forgive me.
Yes.
I asked a question because I just need to know.
Yes, where we are.
Where you are within the broad scheme of how the case has been argued.
Yes. Let me just give Your Lordship an assurance that I'm not going to, like now I'm addressing you on the breach of the rule of law a la the declaratory order. When I deal with the review relief, my Lord, I'm going to assume that Your Lordship has that to the extent that there's an overlap between the rule of law, Section 1 and Section 33 of the Constitution, Your Lordship, I'll take that as understood. I'm not going to now again and say it's arbitrary because of this and that. I'm simply, forget the labels. I'm showing you that the conduct breaches the rule of law. That's, for now, for the purposes of the declarator, but the same...
now, what conduct is this?
Okay. When you... The conduct... The culture of justification, my Lord, relates to, or at least let's take 172 1A. It says that whenever you can show that a law or conduct is inconsistent with the Constitution, then the court must declare it to be such and invalidate it and so on. Your Lordship knows that. So here we're not talking about the unconstitutionality of a law as such. We do that later in the alternative, in one of the alternatives. We're talking about the inconsistency of conduct. And the Lordship asks what conduct is here. Well, the conduct, my Lord, manifests itself in, and for the purposes of the Lordship will forgive me, I'm giving the long answer for a reason, so that, again, I don't have to cover this. Remember, the Public Protector was impeached in September last year. And according, at least in terms of the Basic Conditions of Employment Act, she should have been paid all her remuneration 7 days thereafter. So what she then did was to write a series of letters and to demand that payment. And then it was said that
But she wasn't demanding remuneration, she was demanding payment of a gratuity. Does anything turn on that distinction?
No, my lord. I spent a long time explaining, my lord, that the remuneration heading in section 219 encapsulates...
It's got 3 elements that you submitted.
And that
yes.
Those 3 elements, and then I took your lordship to the service conditions. And I showed your lordship where each of those 3 elements appear. The salary is here.
No, I follow.
Okay, and I'll come back to this, because if it worries your lordship, then it means I didn't explain it properly.
No, forgive me. I do follow your case. Is
yes,
that your case is that a gratuity falls within the category remuneration on the basis that a gratuity must be taken to be encompassed within the meaning of benefit.
No, yes, I'm saying on 4 reasons. 1, section 2195 has a heading called remuneration, and then it at some stage gives birth to a thing that has gratuity in it. So there's no escaping it. It can be, if it's about those things in 2195, it can now suddenly contain some other foreign thing. So it's that's 1. 2, I say the word remuneration as defined in the Basic Conditions of Employment Act says it is service that you give, including service to the state. That's what she did. 2. 3, I say that the Judges Remuneration Act, among other things, talks about gratuity. So if that is called the Remuneration Act and it deals with the payment of gratuity, then it must follow that gratuity is part of what that law is about, which is the remuneration, right? And then the other one is the reliance on the scheme of the Act, which says that in any event you may not contract for something less than what is in the Basic Conditions of Employment Act. There are others, but at least let's just live with those 4. So I hope that let's bury that issue of whether the gratuity, and it says, and I've used the example of the word shall to explain that it creates a legal obligation. So let's put that aside. Yeah, okay, I've forgotten where I was.
I sort of, you were dealing with instances of what constitutes conduct in the context of the conduct having breached the rule of law.
Thank you,
and it mentioned 3 things.
Yes.
Impeached in September 2023.
Made
she
demands.
was due remuneration within 7 days after.
Correct.
And that she demanded remuneration.
Yes, my lord. Yeah, no, thank you. Your lordship asked me the question at the point where I was saying she made demands. Your lordship then made the distinction. Well, I'm saying she made demands because I'm making it for the gratuity. Yeah. Whether the gratuity forms part of remuneration for current purposes is another point. So she made those demands, and the public protector said, we don't have the powers to deal with this. I'm paraphrasing the history. We don't have the powers to deal with this. We're going to ask Parliament for guidance, quote unquote, because we think it's the Parliament that has the powers. We write again in November, December. We say, please, this is obviously onerous on the public protector or the former public protector. They say, okay, we'll answer you in January or something. They don't. Or the 2nd of February. They don't. Eventually, we get this letter that we went through at 02-233. And all of a sudden, The same people who said we don't have the powers, we seek guidance, all of a sudden now have the power, they make the decision, and they give reasons about removal per se being the disqualifying factor. And the only reason we are told, my lord, that there was that dramatic change of attitude is because they had an opinion from senior counsel, unknown senior counsel somewhere. That's the only reason, at least given in the papers. So the senior counsel, we don't know who it is, we don't know what he said, we don't know the nature of the advice, and we are told it's privileged. Well, firstly, the privilege doesn't apply, but I don't want to bore your lordship about the law of privilege. But let's assume that it did. The obligation of an organ of state, my lord, the minimum obligation is to say to your lordship, well, we got a legal opinion. That legal opinion said, indeed, we do have the power, and it also said, hopefully, that if you do not vacate of your own volition by removal, you are out. So we have to read that between the lines.
Well, they could. The opinion could have been for or against the applicant, but then they could equally have ignored the opinion.
Yes, but exactly.
And them ignoring the opinion, whatever the opinion might have said, for or against the applicant, but on the face of it, nothing will turn on it, because ultimately what the court will have to decide will be what the law has to say.
No, my lord. Let's take one of your scenarios, my lord. Let's say, assume the opinion said, are you out of your mind? You must pay her. And your lordship is saying that would make no difference.
Well, they could ignore it and say, well, thank you very much, counsel. We asked for an opinion, and you gave an opinion for our own reasons. Having reflected, we take a different view.
Well, if that is the case, my lord, then, as I say, I'll just sit down. Because what that scenario would mean, my lord, is that, one, you have an organ of state that says, we don't know what the law says. It is up to Parliament, which then goes and says, we're going to get, because we don't know, we'll get a legal opinion. And that legal opinion says, no, you must pay. And they don't pay. If there ever it is a definition of irrationality, that would be it. Because my skin crawls to think that we could allow our organs of state to behave in that fashion against citizens. Because that would then show what we say, my lord, that this whole thing is motivated by malice, vindictiveness, bias, and all sorts of... because which organ of state, honestly, would do that? But let's assume that is rational. I don't even know how to articulate that. Then all I was saying, my lord, is that your lordship, at the very least, should be saying, tell me, please, Mr. Organ of State, that the opinion said, you don't have to give it to me, right? Because it's quote-unquote privileged. But what stops you from saying that it said that a gratuity is not paid upon removal, which is what it seems is what it must have said, because the letter on 02-233 says that. And then your Lordship would then say, okay, if you are relying on that legal opinion, which is wrong, patently wrong, for the reasons I've explained, because it would include incapacity. If you are relying on that legal opinion, at what point did you then graduate the reasons to what is found in your answering affidavit? Which would double irrationality if there's such a thing. So, your Lordship, with the greatest respect, cannot be, shall we call it, unconcerned about that which you are told in the papers under oath in an affidavit was the source of why we are before you today. The opinion from so-called senior counsel, unnamed, senior counsel. Anyway, I really don't think I have to belabor that point any further. But then the point is, so that's the first in this chain of conduct. Then the apex is then the letter of the 12th of February 2024, because that's when the decision is communicated, right? So, and again, I don't want to be a person of labels. So the conduct is what I've just described up to that point, including the inherent bias and illogicality and so on and so on. And the fact of the matter is that that conduct, my Lord, on the face of it, violates the rights under Section 23, as explained in the BCEA, violates the rights under Section 10 of the Constitution, violates the rights under Section 9 of the Constitution in the manner that we explained, which is that other public protectors were given their gratuity, and the basis upon which this...
Why would the applicant rely directly on Section 9 and 10 of the Constitution?
Because, my Lord, because it's the okay. I don't want to, again, to be bogged down on a debate about subsidiarity, but let me give you this example. I mean, this short answer. One is that here we're talking about irrational differentiation in the hands of the state. So irrational differentiation, as was said in all the cases, is per se a breach of Section 9. But it's also an element of irrationality, again, in the sense that I've said, either as a...
But that doesn't excuse having to claim an infringement by referencing an appropriate legislation that deals with what Section 9 and 10 of the Constitution deals with.
Okay,
then
we'll address your Lordship on, I'll give there's a case that deals with that. Sorry, I was not anticipating that. Forget about that. Talk about Section, okay, no, don't forget about it. Even if your Lordship is correct, your Lordship surely cannot be saying, I hope, that, for example, if you are using the equality standard, I think that's the best word there. For example, you know that your Lordship knows that one of the interpretational rules is that your Lordship is not allowed to interpret a contract or a statute or whatever so as to produce inequality. Even just at that level, forget about Pepuda and all those things. So that's number one. So even as an interpretational standard, the mere fact that other people were treated in a particular way is a factor that your Lordship should force your Lordship to interpret the the issue in a separate way. So that's the first answer. The second answer is that I've just referred now to the Basic Conditions of Employment Act, which is subsidiary to Section 23. I've referred to your Lordship to Section 10 of the Constitution, which is human dignity, and that it's not susceptible to any subsidiarity, so you can apply it directly. So Section 22, I don't know if we mentioned it, of the Constitution. So all those other, so it really doesn't matter, this debate in the larger scheme of things, in the sense that and insofar as we rely on Section 33, we invoke PAJA, which is the other subsidiary legislation. But now, okay. Sorry, I've lost my train of thought. Okay. Now, I was saying, my lord, that
Yes, I asked a question after you had been making a submission that the conduct violates rights, and then you had started enumerating the rights.
I was saying, okay.
And you got to Section 9 and 10 of the Constitution, at which point
okay.
I then...
I'll skip Section 9. Let's say you're violating the conduct that the applicant is saying has been violated, or rather has been committed. She says violates Section 1, I've already said, Section 1 of the Constitution. She also says it violates Section 7, bracket 2 of the Constitution, which says that the state must respect and fulfill the rights in the Bill of Rights. And then she says let's skip 9. She says you violate Section 10 of the Constitution, which is human dignity. Then she says you violating Section 23 via the BCA, and she says you are violating Section 22, I think, of which is the right to practice your occupation. Or which one can pick any of those. But certainly, on the Wachenuka scale, remember we've quoted the case of Wachenuka in which was Justice Nugent's formulation of the rights which emanate from Section 23, really. It's a whole debate. I'm sure your Lordship is familiar with it, that about the true ambit of the Section 23 rights. That it's not just about you work and you get paid. It's not just about money. It's also about the inherent self-worth, the dignity of working in the first place. And this is what was said in Wachenuka. You'll find that at paragraph 76 of our heads. It's Minister of Home Affairs versus Wachenuka, 2004, 4 SA 326 SCA. So the freedom to engage in productive work, even where that is not required in order to survive, is indeed an important component of human dignity. That's Section 10 of the Constitution. As submitted by the Respondents' Council, for mankind is preeminently a social species with an instinct for meaningful association, self-esteem and the sense of self-worth. The fulfillment of what it is to be human is most often bound up with being accepted as socially useful. In less flowery language, what that means is that the rights in Section 23 encapsulate also the right to work and the right to human dignity. So if you accept all that, then, my Lord, it comes to what your Lordship said to me in the morning, which was quite correct. Then would, now looking at it purely from a Section 172(1)(a) point of view, then your Lordship, unless there is justification for that conduct, which obviously adversely affects those rights, then your Lordship has no choice, but you must declare that to be inconsistent with the Constitution. So that series of conduct, which started in the refusal, the not knowing, quote unquote, the obtaining of legal advice, which, according to your lordship, possibly actually advised the opposite, and then and the writing of an illogical letter explaining the reasons on the 12th. So it culminates on the 12th. So that's the conduct. It is only when you get that letter of the 12th, my lord, which basically then explains, because you have to wait until you couldn't have come to court, let's say in December. You need to have completed conduct. Once that conduct was completed and then encapsulated in the letter of the 12th, at that point the legal right under Section 34 of the Constitution then arose. In other words, there was at that point a dispute, because now we knew the parameters. They are saying a removal disqualifies you. We're saying a removal doesn't qualify you. That's called a legal dispute. So at that point, the dispute envisaged in Section 34 of the Constitution arose. That's why we're here. So that's the conduct, and your lordship, excuse me, the reason I gave you the long answer to that conduct is because it covers all sorts of other things to do with review as well. I'm trying to plow ahead. Now, but in simple English, the conduct, my lord, is the refusal or failure to pay the gratuity. Mentioned in the service conditions. And when you go to the alternative review relief, just to preempt, your lordship, if you'll ask me then, what is the decision? The decision in terms of either parja or legality, the impugned decision at least, is that which is encapsulated in the letter as well, for the same reasons. It just happens to give rise to different causes of action. That's why they are pleaded in the alternative. Could have been 10 causes of action, but it's just, well, that's how.
I believe you've come to the end of that part of the submission on why the court, according to the applicant, ought to grant a declaratory relief.
Yes, madam, and yes, that's correct, madam. And in fact, your lordship's last question just assisted me. Your lordship is quite correct. So, in sum, what we're saying, my lord, is Section 2195 is the source. It gives rise to the Public Protector Act and the service conditions. We say that the interpretation of vacation is not this narrow one about only voluntary vacation, clearly. And then we say the definition of remuneration, both in the Judges Remuneration Act and in terms of Section 2198, includes gratuity. And then we say, my lord, that the series of conduct violates one or more of the fundamental rights contained in Chapter 2 of the Constitution. Doesn't matter which one. You can pick and choose. If it's Section 33 or Section 10 or Section 9 or Section 22, whatever. It doesn't have to be many. One is enough. And then we say, because of that those twin towers, as it were, which both come from the Constitution, Section 219 and the Bill of Rights. I'm using it generically, having been breached in the sense that we've explained. Your lordship has no choice but to declare such conduct inconsistent with the Constitution to the extent of its inconsistency. Yes, madam. Now, sorry, madam, let me just go to the 10 Commandments. just to make sure that we've covered everything. So the first one is at paragraph 55. Then we go on. That's where we deal with gratuity, own volition, and so on. And then, sorry, I just want to make a note. There's something I need to. Okay. And then the second one is the one about the introduction of words. In other words, asking the court to rewrite that clause, basically, to include things like with a clean record, without blemish, in good standing, and all that, which are not there. And the third one is 8.11. We've discussed that. The fourth one is the AU's generis, AU-STEM generis rule. That's where we spoke about remuneration, meaning salary, medical aid, and all sorts of other things which are not specifically mentioned. The fifth one is the Basic Conditions of Employment Act and the extent to which it supersedes any contract of employment. The sixth is the comparison with the local government issues, but you can, don't have to discard that, you can take that into account, but the best one is the one of judges, which we've done, the comparison with the judges' remuneration. Seventh one is the subsidiarity point, where Musaneka said that a statute like the BCEA is umbilically linked to the Constitution. In other words, it's the same as if you were applying Section 23. You just do it via another thing. And then Wachenuka, we've dealt with that. Number 8 is the 7.2 of the Constitution and Section 195 of the Constitution. I didn't mention 195, but your Lordship knows that's the one about acting ethically without bias and so on, which is imposed on every organ of state. The ninth one is, the ninth one is the one we have not dealt with, my Lord.
Is that still within the first framework?
Yes. All of that is under Section C, which is the rationality in our heads, yes. I'm just jumping to the 10th one because there's only one that's missing. Or the 10th one is that there's no Section 36 justification which has been pleaded. That's obvious. So there's no law of general application. That's the Sobuko clause thing. So you can only justify this by a law of general application. You can't just create your own law.
Would they plead Section 36 in relation to...
Section 10, for example?
No. Would they plead Section 36 in relation to the conditions of service as a term of the contract?
Yes, my Lord. If we are able, as we have done painstakingly now, to link the conditions of service or anything, whether it's driving a bus or whatever, to Section 10 of the Constitution. In other words, we say the way you are driving this bus is violating my right to dignity. Then it's not saying that you are linking the driving of a bus to Section 36, but you are linking the outcome or the alleged outcome, which is the violation of the human dignity or whatever it is. Yeah. So that's the whole point. So the example I gave of COVID, or unlawful arrest. Yeah. If you put me in a cell, I'm not. When I go to court, I'm not going to say, "Well, it's about a cell. It's about you've violated my right to liberty and freedom of movement, and therefore it's Section 12 of the Constitution."
Forgive me, Mr. Mpofu, and of the 10 points, what is number 9 again?
Yes, number 9 is that's the only one that's missing, my Lord. I'll deal with it very quickly. It's you'll find it at paragraph 78 of our. It's also just it's an important one, my Lord. It's a what you call it, interpretational aid. Now we say, my Lord, remember where we started, that these respondents really want to introduce a forfeiture clause into the mix, which doesn't exist. Now we say that if you look at Section 89 of the Constitution, Section 177, Section 89 is about the impeachment of a judge, of a president. Section 177, the impeachment of a judge, and Section 194, the impeachment of a head of a Chapter 9 institution. Now, again, simple basic interpretational rules. Where the constitutional drafters, my lord, wanted to introduce a forfeiture clause, they didn't do it in a cagey manner.
So I suppose the submission is that the contention is that the respondents, first and second in particular, have imposed the forfeiture clause in their reading of the events, and the claim by the applicant is that they are not allowed to do that because there is no foundation for that. And as part of the illustration by the applicant, the court is referred to Section 89, and the attention is drawn to the extent that there was to be a forfeiture, it should have been written up in a way that it's been written up with the President. Is that the point?
Yes, the point, my lord, is that, yes, no, your lordship is quite correct. The point here is that the constitutional drafters are not, must be assumed to be logical people. So when they sought to introduce a forfeiture clause because of whatever the impeachment of a president, in Section 89(2), they put it without any fear. And it says, my lord, anyone who has been removed from the office of the president in terms of sections 1A or B, in other words, incompetence, and again, this proves the point I was making earlier, that incapacity can never be included in these things, just as it was done in that letter. Yeah. So in terms of 1A or B, in other words, serious violation of the Constitution or serious misconduct, but not C, which is the inability to perform the functions of office, that's incapacity. So if you've been impeached for those two quote-unquote blameworthy things, then you may not receive any benefits. Here's that word again. And benefits here we've shown in terms of the Act, that includes the gratuity, which is comes as a...
Yes, well, I mean, that is the contention by the applicant.
No, that is the contention by the legislature in Section 11 of the Remunerations Act.
We've been through that.
Yes. Well, looks like we have to go back.
No, don't go back.
So
forgive me. All that I'm saying is that the respondents say that a gratuity is not part of remuneration.
Yeah.
And their case is as set out in the papers, and the applicant makes a different case in a way that you have already made it.
Right. May not receive any benefits of that office, and may not serve in any public office. Now, the curious thing about that, my lord, is that it says two things. It's a real forfeiture clause, and it defines the ambit. You can't just dream up a forfeiture clause as you go along every day you wake up. You need a forfeiture clause is what you call as a penal provision by definition. It's a provision that introduces a penalty. That's why it's called a forfeiture clause, because you forfeit that which has accrued. Anyway, so this forfeiture clause has got two elements. You may not receive any benefits, and we know that if it was a judge, it would include gratuity. If it was a public protector, and for the submission that we've made, it would also include that in terms of the service conditions of that office, and may not serve in any public office. We know this applicant has told you, my lord, that she's a member of parliament now, as we speak. So if she was a president, she would not be allowed to serve in any public office, because the forfeiture clause in that section would apply.
Yes, she wouldn't be allowed to hold public office.
Yes, Same as if it was a judge. We know the example of Judge Kholeka, for example. If the forfeiture clause applied in Section 177, then he as well would not be able to serve any public office. So you can't have somebody like these respondents coming up to say, Ms. Mkhwebane or Judge Kholeka or Dr. Kholeka, you may not hold office. Why? Because you were impeached for misconduct and what have you. The answer will be, well, where the drafters of the Constitution wanted that forfeiture clause to apply, they have said so. The omission of that forfeiture clause in Section 177 and 194 must be assumed to be deliberate. And if it is deliberate, it simply means that the forfeiture clause does not apply. I mean, that's interpretation of any instrument, as it were, not just the Constitution. So what does that mean? That means that that's why if this forfeiture clause was not here, then we would have a situation like we have today, where a party would come and say to a president who's been removed for incapacity, you may not have your benefits and you may not hold public office. But because we have a forfeiture clause that circumscribes and explains the limits of the forfeiture clause, not one that is invented every day we wake up. That's what is said. And we say this is hardly surprising because of the nature of the office of the president, as well as the different standards of impeachment being serious misconduct or incompetence as opposed to mere misconduct or incompetence. Such systematic interpretation is particularly appropriate in respect of penal or otherwise harsh provisions. I don't think anyone is going to argue that the forfeiture clause that is the imaginary forfeiture clause that they want to smuggle into the framework is not penal in nature. Yes. So there might well be many rational reasons why there's no forfeiture clause which by the way the former public protector and former Judge Kholeka are beneficiaries of the absence of that forfeiture clause in
yes, I believe the point. I believe the point has been made.
Yes.
That the conduct by the respondent amounts to a forfeiture on the part of the applicant that is not allowed because there's no provision for it in the law.
Yes. And then, my Lord, if I may, just refer your Lordship, again, I won't develop the points, but there's a case that you will find at page 96 of our bundle of authorities. There are two cases both from the Labour Appeal Court, and another one is on page 85. The one at page 85 is called Apollo Tires versus CCMA 2013 5B LLR 434 LAC. The judgment of Musi AJA. And I'll take your Lordship to paragraph 25. I don't have to. It talks about, we've had this discussion, what is meant by benefit? And effectively, it says the definition of remuneration in the Act is wide enough to include wages, salaries, and most, if not all, extra benefits.
Yes, but you've dealt with that point already.
Yes, I'm just giving you the case reference.
Right.
And at paragraph 26, you'll find that as well. And then the next case is ZAPOP, ZAPOP versus CCMA. It's 2016 BLLR 910 LAC, judgment of Sutherland JA. And I refer your Lordship to from paragraph 33, where here you can substitute the word gratuity for commission or tip or whatever. It says, yeah. He says at paragraph 33, the argument runs that the BCA does not prescribe an entitlement to, quote, commission as distinct to entitlements, e.g. accrued leave and ordinary blah, blah, blah. 34, the argument overlooks the fact that it is a contravention of the BCA to fail to pay an employee remuneration that is due. The legal obligation to pay remuneration apart from the contract itself is contained in section 32 of the BCA. 32.4, that's the one that we have.
Yes, but this is not in dispute that she's entitled to remuneration.
Yes.
The point of contestation is what are the elements of remuneration.
Yes.
She takes a particular view, they take a different view.
We've gone through that. I'm not going back there. I'm assuming, my Lord, that we've gone through that debate. I know what they're saying. I'm saying, okay, unless if I have to say, okay, assuming for the purposes of this case that what has been said before about remuneration of judges and so on, I'm not going to go through all that. Assuming that to be true, then this case says that the legal obligation arises from section 32. And then it says, which is the important part, which really comes home to this case, that...
There's still paragraph 34.
34 now, my Lord, yes.
Right.
Assuming there was no binding forfeiture provision, which is really what we're dealing with here, in the contract of employment by reason of policy, change or practice, issues were addressed elsewhere in the judgment. The ancillary argument, because of termination, must pay all remuneration due to an employee within 7 days. And because that cycle, then it goes on. Then, my Lord, I'm just jumping
yes,
to...
Yes, but there is no dispute that in law, a person is entitled to remuneration within 7 days of termination of employment.
No, that's definitely not the point I'm making. I'm making a point about the forfeiture clause, a different point altogether. Paragraph 38, it says, at the time of the conclusion of Cunningham's employment contract, and retrospectively effective to 2006, no forfeiture term was stipulated, even orally, nor could one have been tacitly inferred from what was agreed. That's the point. The point is that at the time of the termination of Ms. Mkhwebane's contract, there was, to use the word, no forfeiture term was stipulated, even orally, nor could one have been tacitly inferred from what was agreed. In other words, from the service condition. And then paragraph 41, that leaves only the notion that by unilateral decision, which is what happened here, in adding a policy forfeiture, Cunningham was retrospectively bound based on the provision in her contract that she was bound by these policies. And further down, the idea of a forfeiture of remuneration already earned is in a different class. If it did not exist to begin with, it needed the employee's assent, which was withheld. That's from a different section of the BCAA, which is the argument, the so-called set-off argument, which is bizarre, to say the least. So the argument is that because she used so much money for legal fees and what have you...
No, that's not the case that's been pleaded.
Well,
the respondents are not saying that well, to use the language that you are making submissions on, that there should be set off. But Mr. Mpofu, the court is going to. I've really text the court staff. I can sit forever, but the court staff should not be obliged to do that.
No, absolutely, my Lord. I'm sympathetic and indebted to everyone.
Right.
Yes, my Lord. Yes.
But forgive me. But the point is this: I believe the court understands the point that you are making, and I'll go back and reread your papers.
Yes.
The point is, as I understand, the conduct by the respondents amounts to imposing a forfeiture clause on the applicant, and there's no basis for that.
That was the first point. I was getting into another point now, which Your Lordship said is not the point, but and I'll deal with it when we come back. Which was that the forfeiture clause that is being introduced, and there's another case called Bogu. I'll give you. It's also part of the thing. Cannot be unilaterally introduced, and cannot be introduced on the back of what Your Lordship says that's not what they are saying, but that's exactly what they are saying. To say that because they say because they were, I think, impoverished or something like that. That's one of the words that they used, or out of pocket, because of they were made out of pocket by this and that and the other. The former public protector cannot be entitled to the gratuity. They might not have used the word set off, my lord, but that's what it means. What it means is simply that if you owe me X,
Mr. Forgive me, I had not paid attention to the clock. I must ask you to pause your submission.
Yes.
And the court will take its break now again for the staff.
Yes.
And then
yes, we'll
I thought you were about to conclude the first part to your submission, and I thought I do understand the point that you are making, namely again that there is a forfeiture. It is impermissible because there is no foundation for it. I appreciate that the further submissions that we're going to make will be to illustrate the point, but I believe that you have made the point.
Yes, no, thank you, my lord.
All right, so I'm going to, the court is going to rise now, and hopefully on resumption, then the applicant will address the court on the other related aspect to her case. Unless, Mr. Mpofu, you do feel that you haven't concluded the part of your address as to why the court should give a declaratory order.
Well,
but you let the court
whatever
know.
that feeling is will be communicated when you come in.
You let the court know after the lunch hour.
Yes.
All right.
The
court will rise now.
Sorry. Can you check? Hello. Sorry. Hello. Can you check what time he wants us to? Did you say 2? Oh, good. Okay. Yeah, at it. Oh, you want Okay, take the whole laptop. Now I want to.
You're taking your laptop now? Yes. But my phone is here.
Oh, is this yours? Oh, I just took it.
May the court rise?
I understand the lordship came back at 2, only to find the court empty, at least without us.
That is so, Mr.
No, I just wanted
Mkhwebane.
to apologize on behalf of my team.
Yes.
Our understanding was that the lordship had said we would take the 1 hour adjournment at 1:15.
Yeah.
That's why we intended to be here at 2:15.
Yes, I appreciate it was a misunderstanding. Mr. Mpofu?
Mr. Mutau protests at my description of the court being empty.
Yes, it should be mentioned that Mr. Mtau was here at 2.
Well, my lady, sorry, my lord, I will deal with that when I deal with the interpretations of my conditions of sense. Yes, your lordship.
Well, all I can say is that he's not going to get a gratuity for that. My Lord,
Mr. Mpofu.
yes. I just wanted to round up one issue by referring your lordship to, under the main section, to paragraph 50 of the Apollo case that I referred to.
1-5.
50, my Lord.
50.
Yes.
Yes.
And in that paragraph, Justice Sutherland relies on a case called Imatu versus Umhlatuze, and says, quote, and this covers, by the way, the next point which they rely on the other side. So you remember, my Lord, that they say it's not a legal entitlement. Then they say it's a discretion. And we say it doesn't matter. If it's a legal requirement, as I've explained, then X what happens. But we're saying even if it's a discretion, then that discretion was exercised capriciously because we were not given a hearing and so on, which I'll deal with in the next section. But here I just want to show that in terms of the law, again, that distinction is not relevant. And the part that is found, that is quoted at 50 says, he says the court concluded that, quote, the more plausible, you'll find that at 93, Mala, of our bundle. It says the more plausible interpretation is that the term benefits was intended to refer to advantages conferred on employees which did not originate from contractual or statutory entitlements, but which had been granted at the employer's discretion. In other words, even if the discretion non-discretion divide could be held in their favor, it would not detract from the fact that this is a benefit. And then his lordship said, it seems to me that the court in Imatu was concerned that if benefits include a statutory or contractual right or entitlement, the right to strike might be curtailed. As pointed out above, the employees will have an election to strike or to go to strike. and in respect of many rights disputes and so on. That's irrelevant. Here's the point. In my view, the better approach would be to interpret the term benefit to include a right or entitlement to which the employee is entitled, bracket, ex contractu or ex lege, including rights judicially created, as well as an advantage or privilege which has been offered or granted to an employee in terms of a policy or practice subject to the employer's discretion. In my judgment, benefit in section 186.2 means existing advantages or privileges to which employer is entitled as a right or granted in terms of a policy or practice subject to the employer's discretion. So the point that was made there is that that distinction, to the extent that it's raised, is not relevant. The benefit would still be a benefit. Now, my Lord, if I may then move to the maybe let me round off the point as follows. If your Lordship is, well, your Lordship doesn't have to be with us. If the Constitution is with us. If the Constitution says that benefits, such as the ones that we've described here, fall under the umbrellaship of remuneration, if the definition of remuneration under the BCEA also encapsulates benefit, as these cases seem to show, and if the remuneration, which is referred to in Section 2.2 of the Public Protector Act, also gives rise to the, among other things, the gratuity, then clearly the two principal questions would have been answered in favor of the applicant. A, being that vacation is not confined to voluntary vacation, and B, that remuneration includes gratuity. And if that is true, then obviously Section 32 of the BCAA kicks in, which means that it was payable within 7 days. Or that the non-payment thereof is a breach not only of the service conditions of the BCAA, but also of Section 219 of the Constitution and Section 23. And if that is so, then the declarative must be counted. Now, if we then, my Lord, move to, and again, I acknowledge the overlaps, and hopefully, therefore, it was not going to take us too long to deal with the review aspect, because half of it, quite frankly, has been covered in everything that we've said earlier, particularly regarding the point about the bias and the absence of a hearing and the unequal treatment or irrational differentiation. But I was just troubled by something before we broke, my Lord, where the Lordship was suggesting that the respondents are not saying that because of the the expression, I think, is of the financial burdens which are allegedly caused by the
set of issue.
Yes.
In quotation.
Yes, absolutely. Yes, that's exactly in quotation. But my Lord, I really would. I'm not going to develop the point further. I want to implore your Lordship simply to read the case for both respondents. The reason that they go to town ad nauseum about this and that charge, and then even compromise the safety of the lawyers by saying the lawyers end this much so that we can be mauled by kidnappers, and all that long is only in aid of one thing. It is in aid of saying that a person who has impoverished, quote unquote, that office to that extent is ipso facto a victim of the artificial forfeiture clause. And when I use the word set off, my Lord, I'm using it in the following sense. There's a case, and I will give your Lordship the reference tomorrow, which says that, it might even be one of these cases, it says that in those situations, the requirements of the law is that the employer should institute civil proceedings about whatever they think that they are owed. They can't simply wake up and implement the equivalent of a set of quote unquote. And in any event, that is outlawed by the provisions of the Basic Conditions of Employment Act. Because the Basic Conditions of Employment Act says if you are going to set off anything for an employer, you must do so with consent, with the consent of that employer. I think it's paragraph 70. No, it's not 70 something. There's no 70 something. 7 bracket 9 or something. I'll get the reference. So it would not just be against the normal interest of justice, it would also be against the law. But let's put that aside. Let's then come to the review leg. The review leg of the case, my lord, is much simpler. And it is this. And for the purposes of this, you have to no, let me do this one also. Before I go to the review leg, let me round off the other alternatives very quickly. So this is how the case is structured. We say, one, the declarator that we've been discussing. If your lordship is with us with that, that's the end of the case. And then the lordship would then give remedial action in terms of 172(1)(b). But we say that if your lordship, for some reason, finds that this forfeiture clause actually exists, then that new clause, re-engineered to include the penal forfeiture clause, would be unconstitutional in the sense that it would be introducing an arbitrary standard which has no basis in law and is, as I say, extensible and elastic according to how everybody feels. Thanks. So the constitutional attack is in the alternative in that sense. Your lordship knows, I don't have to lecture your lordship about the Hande test. So the first duty for your lordship is that in terms of the Hande case, your lordship must in any event interpret these documents in favor of the citizen, in favor of liberty, and in favor of or against inequality, oppressiveness, and absurdity, and all those things. But if all that fails, then your lordship will be left with the reality of the clause that they postulate being there, and we say in that case that clause would be patently unconstitutional. And I don't have to motivate again for the same reasons that it would offend against the most basic norms of justice, as is said in the Wachemuka case, for example. And then, my lord, if your lordship then does that, what we call specific performance, stroke, you can call it specific performance or substitution, whichever way you want to call it, is that if that clause is then found to be invalid, then obviously your lordship's remedy would be to order that its application was ab initio unlawful and the gratuity must be paid.
That is, if clause 3.1.
Yeah,
clause 3.
Let's say 3, yes.
Right. But the case made on paper is that, which is an alternative, is that the law be declared, as it were, to be contrary to public moral.
Yes, that's the same thing. It's say public morals.
But why is that the case? Okay. On a facial consideration of the clause, why would it be as it stands?
Well, my lord, by definition, what used to be called the legal convictions of the community, the rechtsoortegings van de gemeenskap, which was a concept that was developed in the case of Evels versus Minister of Police. It is now fact that that concept, which was the embodiment of the Bonnie Morris of society, that concept has now been, is just as good as saying the Constitution. In other words, the nation has decided to embody its legal convictions in a document called the Constitution.
Yes,
so,
but forgive me, that is what the law says.
Yes.
Now, as to the substance, why is Clause 3 said to be contrary to public morals?
Right.
Because that is the relief sought in the alternative.
Yes. The submission is this, my Lord. Not Clause 3 as it stands now. I've addressed your Lordship as to Clause 3 as it stands now. I'm saying the new Clause 3 that has the forfeiture clause. That's why it's the alternative. So if the court finds that there's a new Clause 3 which incorporates the forfeiture clause, in other words, that their case on the interpretation is such that there is such a forfeiture clause. I mean, I don't know how. But if that happens, then it is that Clause 3. I don't know if it's clear now.
All right, I see.
Yes,
I follow.
that's
So
why it's called the alternative. It is that Clause 3 that would be unconstitutional, not this one. This one we've explained.
That's not how I understood the pleaded case.
Okay.
I understood, but I followed the submission. The submission is the applicant doesn't take issue with the clause as it stands, but to the extent that the court is with the respondent in interpreting the clause in the way that we've made the submission, that is incorporating the forfeiture clause as you have submitted, then in that event, the clause is to be Clause 3 is then to be interpreted as being contrary to public morals. Is that the case?
No. The case is this, my Lord. It is not that the applicant doesn't take issue with Clause 3. That's what the whole morning is about, us taking issue with Clause 3.
No, but we've gone past that. We're
yes,
now dealing with
we're
dealing with the alternative. I'm aware of that.
In the unlikely event that the court finds that there is a forfeiture clause incorporated in Clause 3, then that resultant clause would be unconstitutional and I hope, I know that I don't then have to traverse the reasons why a penal forfeiture clause which deprives the rights that I've defined in the morning would ipso facto be it's like saying if there was a clause that says you can be arrested for no reason.
Okay. No, I follow.
Then that clause would be unconstitutional.
I now follow.
Excuse me. Excuse me. And your Lordship will find that at 02-3, which is alternative to prayers 1 and 2, declaring the Clause 3 of the public order to be illegal, null and void, unenforceable. Excuse me. Sorry, my Lord. Anyway, that's the alternative. The next alternative at paragraph 4 is a simpler one, which says that prayer 3 respondents to be in breach of the clause and or the BCEA. I've also gone through that at length. In other words, it would be 32.3 of the BCEA. And all read, my learned friends, one of them at least, I think it's Mr. Mkhwebane, say that we're not entitled to rely on the other sections of the BCEA. I've never heard of a submission like that. If the end domain says when you interpret 32, for example, of of the BCAA, you must look at the statute holistically. So I don't know how we can say the court must just be blinkered to Section 32, but not look at the statute holistically.
Well, when the court retires and reflects on submissions, the court will need to know which provision of the BCEA is being referenced. Now that is 32 sub 3.
Yeah, that's in the founding affidavit actually. It says 32 sub 3. All I'm saying is that in interpreting that section, you can't not look at the rest of the statute. I've never heard of such a thing. But so it's always been 32.3 as pleaded in the founding affidavit. But that 32.3 cannot be viewed as an island. It must be viewed in this constitutional context as well as it's. But by the way, the preamble to the BCAA says to give effect to the right to fair labor practices referred to in Section 23(1) of the Constitution. So that's what it is. So it means also in interpreting it, you also have to look at Section 23. Then the other alternative, my Lord, is, in other words, there again, this obviously directly depends on the interpretation of the word remuneration. Because if your court is with us there, then 32.3 kicks in automatically. Then the further alternative, which is where we are now, is the review relief. The reason I'm rushing through these other alternatives is because in our respectful submissions we'll never get there really, because the declaratory relief is self-evidently established. And as far as the review relief is concerned, my Lord, this is what we're saying. At the risk of repeating myself, the organ of state is enjoined by Section 33 of the Constitution to grant certain rights before it implements a particular decision. That's just a layman's understanding of administrative law. And we say that in this particular instance, and again, this is why this is in the alternative, by the way. In this particular instance, you now have to postulate that, because otherwise you can't reach the review relief. You can only reach the review relief if you found that the forfeiture clause is good. Now we're saying if the forfeiture clause exists, then by definition it is what you call a penal clause. I don't think anyone in this room is going to contest that notion, that a forfeiture clause is one that imposes a penalty. In fact, in this case, it doesn't just impose a penalty, it imposes a double penalty, which the Americans call double jeopardy. It's because you've already, for the same conduct, you've already been punished by being impeached. Now they're saying you must be punished again by being deprived your gratuity. So it's worse than a penal clause, it's a double penal clause. But it is what it is. Let's assume there is that double penal clause. Now, if there is that double penal clause, as there is, by the way, for the case of a president, a double penal clause. Firstly, we say a double penal clause would have to be specifically promulgated. It can be implied. But for the purposes of administrative law, we say and this is tried, even before the Constitution came, this was true. When you have a penal type of clause, that automatically attracts Audi. That we can praise the Constitution for many things, but that's not why the Constitution didn't introduce. That was always like that in the olden days.
Mr. Mpofu, perhaps let's begin at the beginning.
Yeah.
In relation to this part of the review.
Yes.
The applicant contends for the conduct being administrative action.
The decision.
Well, that's one aspect which I needed to know as to what in fact the case is. So the decision is what constitutes administrative action on the pleaded claim.
Yes.
Now, in relation to the definition of administrative action, what does the sub A Roman 1 and 2, which heading does the applicant contend for?
Okay, section sub A and 2 of section 1.
In the definitions.
Okay. It says any decision, we accept that decision, or failure to take a decision. When organ of state, we accept that. When exercising a power in terms of the constitution or a provincial constitution. Well, according to them, this is the exclusion is in terms of the constitution. In other words, for example, when they say that we are wrong in the 89.2 provision, they say the exact opposite. They say actually the absence of the forfeiture clause proves their case, that the constitution also intended the judges and public protectors to be subject to a forfeiture clause. I mean, that's absolute.
Well, that's what they say in submission. What I do need to know is, in the first instance, under the definition sub A,
yes,
which of the two alternatives, Roman 1 and Roman 2, does the, well, perhaps I'm assuming. There's sub A, Roman 1 and 2, and then there's sub B in relation to the taker of a
yes.
decision. What does the applicant contend for? Which category does the applicant contend for?
My Lord, I've just said why it's first of all in the aversion category.
No, but see, that's what I don't understand. You say in the aversion, her case, because she's pleading a review in the alternative.
Yes.
So I need to know where to locate that part as far as the act is concerned, not what they say,
Okay.
what she says.
Okay, all right. I'm saying, my Lord, I don't quite understand that, because when you come to court, surely you're coming to court because somebody has done something to you. And so I'm saying that the case of the applicant is that when the public protector were exercising a power in terms of the constitution, well, obviously not a provincial constitution. In other words, in terms of either section 2195 or the umbilical code that is explained by Musaneke J in the Goed 11 case, that's our first case, where Musaneke J says exactly this point, that when you are implementing a legislation such as the BCEA, in that case it was the Land Restitution Act, you must understand that it has an umbilical code into the empowering section of the Constitution. I just read out section 23, the relationship in that umbilical matrix between section 23 and section 23. So the short answer could be something like this: which power under the Constitution are they exercising? I would say it's a power that emanates from both section 219 and section 23.
Forgive me. We seem to be at odds.
Yes.
I just have regard to the definition of administrative action. It says it means any decision taken or any failure to take a decision then by sub A and sub B. Now, I had asked earlier as to which category the applicant contends for. But I'm reminded from the pleadings that the applicant says that the public protector is a decision maker. That's
Yes.
a pleaded case.
Yes, it is. It's not just the pleaded case, it's what the public protector says herself. Right? She says at about 4 places. Sorry, my lord.
Right. The decision maker is the public protector.
Yes. She says, I'm just giving you a random example. If you go to paragraph 29-22, where the heading is the decision-making process. In other words, how the decision was made. She says, in this section, I address the process by which the decision was taken. Right? I demonstrate the decision followed a fair process which was initiated by the applicant. The decision itself was informed by lawful, constitutional, and rational factors in accordance with the responsibilities and so on. That's just one example. There are many places.
That is fine.
And then, sorry, my lord, I'm so sorry. I just want to finish this thought. At paragraph 48, she says, since no further response was forthcoming from Advocate, that's Parliament, it became clear that it was the Office of the Public Protector that would take a decision on how to deal with the applicant's demand for gratuity. Sorry, my lord. Yes.
Yeah, well, I mean, the Office of the Public Protector and the Public Protector are not the same thing.
Yes. Yes. They're not. But okay. The Public Protector is itself a sui generis Chapter 9 institution. It is both an office and a person, but that is irrelevant for the purposes of this case. When we talk about, if you look at Section 5 of the PP Act, it says that, and you'll find that in the Section 5(1) of the PP Act, you'll find that at page 17, of the HUD.
Yes.
Yeah, it says the Office of the Public Protector shall be a juristic person. Okay, so you have the Public Protector in that embodiment, which is the office. That's, if you go to look at the first respondent, it's called the Office of the Public Protector.
Yes.
Okay, so that's the first respondent. So we're done with that. Let's go to the second respondent. It's called Ms. Gcaleka, right? So that covers you always. That's how you always cite the Public Protector. Yes. And if you go to sorry. I'm sorry, my lord. This is. Oh, I'm so sorry. It's, if you go to the notice of motion, not the notice of motion, the founding affidavit. Sorry, my lord. Paragraph 5 of the founding affidavit, that's 02-163, I think, if I'm not mistaken. But in any event, it's paragraph 5. This is how the parties are described. The first respondent, at paragraph 4, is the Office of the Public Protector, also known as PPSA. Okay, that's the juristic person, whose head office is situated at Hillcrest Office, and so on and so on. Then it says the second respondent is Kholeka Gcaleka, cited in her personal capacity as well as in her capacity as the public protector in terms of the Constitution. All right? So and this is a standard citation for the public protector because it caters for the notion that the office, like the Auditor General, the Auditor General is a person, but it's also an office. Unlike the chairman of ICASA and all the other public Chapter 9 institutions.
Yes. Mr. Mpofu, now in relation to a claim or a dispute in relation to administrative action, the Constitutional Court has said that there are 7 elements or requirements to the definition of administrative action. So that is a gateway which the applicant has to satisfy for purposes of the court being able to determine whether or not there was administrative action.
Yes, my lord. But those are trite propositions. It's not.
Well. I mean, the court is aware as to what the requirements are. The issue is whether the applicant has demonstrated them.
Yes.
So, and you'll find those recited in the decision of Minister of Defense and Military Veterans against Mutawi and others.
Yes.
The Constitutional Court,
yes.
Paragraph 33, I believe. Now, so the first one is that there must be a decision of an administrative nature. Second one is by an organ of state or a natural or juristic person. That's why the court was inquiring as to who the decision maker is on the claim. The third one is it must be shown that the decision maker was exercising a public power or performing a public function. Fourth, and that exercise was in terms of any legislation or an empowering provision. 5, adversely affecting the rights of the claimant. I'm paraphrasing. 6, a decision having a direct external legal effect. 7, and that does not fall under any of the listed exclusions. Now, the applicant has to satisfy all these elements.
My lord, with the greatest respect to your lordship, if literal in every administrative or PAJA review, we would first have to deal with all those 7 things. My lord, for example, why must one have to show that this is in terms of an empowering provision? We've been saying the whole morning that there's the service conditions, that's an empowering provision.
Well,
the BCAA is legislation.
Now, forgive me, because I haven't had a case made as to what power
was being exercised.
No, that's something different. I haven't had submissions as to, for example, what legislation or empowering provision the decision is said to have been made in terms of.
Whenever a public body writes a letter like the one it did on the 12th of February, and it says to you as a citizen of the country, I will not do this or I will do this because I am, as I say, that's where we started at 10 o'clock this morning. It can only be saying that I will do this or not do it because I am constitutionally empowered to do so. That is a matter of, it just goes without saying. Well, otherwise, it's not like me. I can do something and they say why, I say I just feel like it. But an organ of state cannot do that. An organ of state can only do anything, literally, even breathing, only in terms of an empower a constitutional...
No, it's the other way around in this instance, because you are the claimant. You have to demonstrate, for example, what power was being invoked, and as part of that demonstration, you might be able to say, relied on the wrong source. That wasn't.
Okay.
They say they
That's
acted on the basis of this.
Yeah.
They couldn't have acted on the basis of that. So
Yes.
it's for the applicant
Okay. Okay. Let's
to demonstrate.
Fine. Let's do it like that then. Okay. They say they acted in terms of a forfeiture clause, which they say should be imported into the empowering provision, which is the service conditions. Okay. So that's what they say. That's effectively what if you read that letter with legal eyes, that's what they're saying. They're simply saying, in terms of the what you call it, regulatory framework, which contains all the things we've been talking about, we can distill a clause. That clause itself, by the way, is an empowering provision. But for that imaginary clause, for the purposes of this, we assume that it exists. Okay. And then we say no, you can't, because the actual empowering framework, I'm using that word loosely, is interpreted in this way. So that's why we said the whole case is about interpretation. They interpret the regulatory, constitutional, and contractual framework to give them the forfeiture clause. We interpret the same framework to say there's no such forfeiture clause. That's what the whole case is about. But there is no duty. This is what I was trying to explain in the morning, the difference between a civil case and one like this, where the traditional owners say, well, you are the applicant. It doesn't work like that in constitutional and administrative law, because we're here about the culture of justification. Once you have established, for example, the prima facie, I mean, for example, it would...
Well, that's not quite right, Mr. Mpofu, because, for example, the court in Sokela and others against the MEC for Agriculture and Environmental Affairs, KwaZulu-Natal, 2010-5 SA 574, the court there said that the requirement that the decision be of an administrative nature is a gateway to determining whether a particular decision constitutes administrative action. So,
Yes.
so it is required to go through the exercise.
Every time. Okay. So if let's assume that is so, my lord, that every case, every court which has to deal with administrative action, the denial of a dog license or anything, has to go through the exercise of saying, okay, well, was this an organ of state? Was it about an empowering provision? What, did it have external legal effect? Did it affect your rights? And so on. Let's assume that's actually how it is. The point we are making is simply this, my lord. Well, we don't think that it would be necessary. Let me just give an example, my lord, and if your court will bear with me. If you say, what is meant by external legal effect? It simply means that it has an adverse effect on the citizen, or whoever the complainant is, even if they are not a citizen. The person who has been affected by the administrative action. You have to take this from Section 33, my lord, of the Constitution, which is where it comes from. It says everyone, that includes this applicant, everyone has a right to fair administrative action. So and everyone has a right to a hearing. Everyone in the exercise of that. And I take your lordship's point, which is that everyone has to, if they are at least exercising Section 33, has to demonstrate that you are in the realm of Section 33. But I'm saying, and I'm going to leave this at this, my lord, because otherwise it will take literally all day here. That those, and your lordship is quite correct, those 7 elements, my lord, I will argue that those 7 elements are are blatant in the pleadings, because we do allege, one, that, for example, the Public Protector's Office is an organ of state, as if we even have to say that, but it's there. We do say that it affects rights, we list them. We do say that it affects a livelihood, so that's adversely, if you like. We do say that the empowering provision does not, and the relevant legislation does not say gives them the power.
Yes,
so all those things
but
are
the
there.
point is, what is the empowering provision or legislation as far as the applicant is concerned? Because she has to say, as far as my case is concerned, this is the legal instrument that I contend for. But if forgive me,
service conditions, right? The thing called the service conditions is an empowering provision. And each party here in this room says that that's what they were implementing. The only difference between the parties is whether the implementation of that empowering provision is this or that interpretation. The second one is the Constitution of the Republic of South Africa. Because each party, again here, says that the Constitution of the Republic of South Africa empowers it to do what it did or didn't do. The parties happen to differ on how to apply the Constitution. But there is no difference between any party here as to whether or not this is a... In fact, at 02-34, you'll find that this is what Ms. Gcaleka says. As is evident from the dispute, which is what we're saying. This case presents serious constitutional issues, particularly related to the removal of office bearers of Chapter 9 institutions supporting democracy. So what is she saying there? She's saying that it's evident and clear from the pleadings and this common cause that the constitutional issues that are so that again, so your Lordship gave me that Roman 1 or Roman 2. That shows that according to everyone in this room, at least, the issue is under Roman 1. But my Lord, let me do this really, because otherwise, as I say, it will just go on for a long time. Your Lordship, we rely on what is in our papers. I'm not going to make any submission regarding any further submissions rather regarding the applicability of PAJA, apart from what we have explained in the pleadings as they stand, what Ms. Gcaleka is saying, and how we have dealt with it in the reply. So let's call that the point in limine. The point in limine, that is, and by the way, and the only reason really that I'm addressing that is that as far as the Speaker of Parliament is concerned, that's the only point they take, the point in limine about administrative action. The other side, wisely, dealt with the actual grounds of review, because you can't put all your eggs in one basket and not deal with the actual grounds of review. So let me do this. I'm going to deal with the grounds of review, and for the purposes of this discussion, it should not matter whether I'm relying on PAJA or legality, because quite frankly, this debate also doesn't take us anywhere, because if PAJA doesn't apply for some reason, either because there's no external legal effect or whatever, the review is brought under the principle of legality. So the review relief is not going to go away just because it's not administrative action. So I'd rather address it from that point of view. Let's look at the legality review. Now, the legality review, my lord, is and please, I don't want to be understood to be saying that the PAJA grounds do not apply. I've made my submission. I'm just saying I'm not going to address it further.
You stand by what's
in the papers, what's in the literature, in all the cases and all that. Yeah. But let's talk legality. Now, the legality review, my lord, is patently based on the following grounds. There's something called procedural irrationality. A lordship might know that this comes from cases like Albert, Law Society, and various other cases. And it really is what you like, if you like, a manifestation of the how irrational it can be in certain cases to deny somebody their rights to make representations or to a hearing or reasons or whatever, all the fairness standards.
The respondents say that insofar as a claim for not having had a hearing is concerned, I understand their case to be that the applicant sent a letter inquiring about the payment, and then there was that exchange of correspondence, yes, which you have mentioned to the court, which culminated eventually with the applicant being with the letter of the 12th. And that they say that that constitutes a hearing.
Well, okay. I don't think they can go that far, but let's assume that they do.
Forgive me, so that's one aspect. They also say that the applicant, in any event, doesn't say what that hearing that she contends for, the form that the hearing should have taken.
Yes, my lord, but that's just palpable. I don't even know how to explain it. Firstly, where does the duty come from an applicant to say this is the form of a hearing? If you owe somebody a hearing, you owe them a hearing. You can't say that they now assume some duty to say no, it must be done in an air-conditioned office, or it must be done in this place or that place. There's no such thing. The duty arises.
Forgive me. How can the applicant not have an interest in the both the form and content of a hearing, while simultaneously saying that she did not have a hearing? I understand the complaint to have within it an expectation of what should have happened or what ought to have happened, such that had that happened, then, according to her, she would have had a hearing.
Well, my lord, really, I must say, it's the first time I hear that the somebody who's complaining of not getting Audi, in other words, let's say an employee, you get kicked out and they say you're fired, and they say, well, what about my hearing? Then they say, now the employee then attracts a duty to say how that hearing should be held, where it must be held, and all sorts of things like that.
But then
where does that duty come
from? If that is so, and if the court is invited as it is to make that finding, how is the court to say that she should have had a hearing, and that hearing must have had the following elements?
Okay. I've answered the first part. How the court should determine whether she should have had a hearing. That arises out of the law. if it's a penal provision, you must have a hearing. That's how. The second aspect as to the form of the hearing, as I say, that's the part that I'm hearing for the first time. That then she must not only say, I was sent to jail without a hearing, but that hearing should have been in the form of a motion proceedings or a criminal trial or a civil trial or whatever it is. No, the mere absence of a hearing, which, by the way, and in defense of my learned friends, none of them has said that there was a hearing. What they are saying is that there was no need for a hearing, and I'll find. In other words, they ignore the fact that this is a punitive statute, which ipso facto, a decision with ipso facto attracts a hearing. But again, let me move on. And I'll make my submission at this and leave it there. One, the duty to have a hearing arose. It arises from everything: the common law, the constitution, fairness, any sense of justice that anyone can think of for anyone who's going to be punished. Then the point is that there was no hearing of any description. So you can invent any hearing you like. You can say it should have been in a formal setting, should have been in a community hall or whatever. None of those happened. So there was no hearing of any description in our version. And to the extent that the exchange of letters is alleged to be a hearing, that is shocking, to say the least. Because you can't have a hearing by somebody saying, please pay my gratuity, and then you come back and you say, I've made a decision that you are not entitled to it. Where's the hearing? How you do a hearing is the following. You say, you go to your senior counsel or whatever, and they advise you that there's a forfeiture clause. Then you say, okay, I've now discovered that there's a forfeiture clause, and because it is penal in nature, I want you to make representations as to why it should not apply to you. You now, no, not in general. That's what a hearing is. If you stab somebody in the street, you get a hearing in the criminal court, because they don't just say, well, you've just stabbed someone, therefore you must go to jail. You must get a hearing to show why you must be exempted from that operation of the law. It's Audi in every form. Yeah. Same thing. If I crash somebody's car, they take me to the civil court to get a hearing. I get a hearing, then I can explain that no, I had a disease or whatever it is. That's the hearing. Now, in this example, the hearing would be, well, the former public protector would say, no. All the things that we're saying now, we wouldn't have had to come here. By the way, one of the functions of a hearing is to avoid having to come to a court, because in that hearing, if you are dealing with an honest organ of state, they might say, oh, we didn't think of that, or we didn't think of the Remuneration Act of the judges, and so on and so on. Therefore, so you can't just say you believe your own I almost said propaganda.
Right. Which other basis does the applicant rely on for her claim based on legality review? You have been mentioning procedural irrationality. What other grounds?
Procedural irrationality.
What other grounds?
Okay. The other ground that is pleaded is the bias. And bias, malice, and the perception of bias. Again, that falls under both the PAJA, but it also falls under the common law. So the Lordship will know, for example, when you are asking for a recusal of a judge, you are invoking bias, but not a la PAJA, because PAJA doesn't apply
and
to
the respondents say that the complaints of bias, malice are unsubstantiated.
Yes, my lord. That's what respondents do, my lord. I can't. Okay. This is how they are substantiated. If that's supposed to be their defense, these complaints are substantiated in great length in the papers, my lord, to show that firstly the mere fact that we're here is an act of vindictiveness and really capriciousness, arbitrariness, whatever you want to call it, because because it's the first time that a party that says, I don't have the power, I don't know if I have the power, and then all of a sudden one day wakes up to say, I now do have the power and I'm going to exercise it against you. It's also the first time, my lord, that a party which has been told ad nauseum that there's a reason why the section 32(3) of the BCEA, for example, which says you must be paid 7 days after the termination of your employment. It is for obvious reasons that it is at that point that you are stranded, quote unquote, and you need to be able to be remunerated so that you can have a livelihood. We are now 3 weeks or so from the anniversary of the termination of the contract, a whole year. And all that has happened is that the person is being punished for a reason that is completely arbitrary and has no basis and has a shifting parameter of the reasons why it is being done. That's not enough. We have we then bring, after the letter of the 12th, bring an urgent application on the 1st of March. The reason why this application is being heard now on the in August is because, and this is all in the papers, the applicant did something which is completely unheard of. For 6 weeks, having been asked to produce a record in 5 days, for 6 weeks they did nothing. And on the eve of the hearing, they produced what we say was an incomplete record and no reasons. The reason they didn't produce the reasons was because they say the reasons are in the letter of the 12th, and I've made submissions about that. But the reasons why they didn't produce a record, we don't know. And if organs of state all over the country can adopt that attitude of saying when a citizen brings an application, when you are bound to follow the time frames that they set, you can just carry on with your life as if nothing has happened. And that is why your sister, Collis J., imposed an attorney and client cost order against and that's also in the papers, against the applicants, because it's not done. We have shown, and I don't want to get into this in great detail, but we have also demonstrated, my lord, that in the first place, the impeachment itself was accompanied by sustained conduct aimed intentionally at denying the legal representation, despite what the Constitutional Court had ordered. Constitutional Court said there is
the impeachment process is not before this court, or is it? I mean, the issues pertaining to that, other than it being a recordal that the applicant went through the process and decisions were made in terms of that process as detailed in the record?
Well, thank you, my lord. If that is the case, then why are we here? Because I thought we were here because the case of the respondents is that the impeachment of the public protector for misconduct and all the things that they then go on, and the incompetence is the reason why they are not paying the gratuity. So I'm glad if indeed your lordship is quite correct that the impeachment process and its ins and outs is not before this court. Well, then I should just sit down, because the very essence of why it is that the gratuity has not been paid will be not before the court. Because the second manufactured reason, which appeared in the answering affidavit, is solely based on nothing else but the impeachment process and its findings. But I agree with your lordship. It shouldn't feature. So then the basic, the real justification. Let's remember where we started in the morning. Culture of justification.
No, forgive me. I think we've made submissions on that. Right. So then, bias, malice, and perception of malice. That's the second basis to the legality review. Are there other grounds?
Yes, there are. The other grounds is in the document, which is taking into account, and unfortunately that also takes us to the impeachment process, which is really the only thing that brought us here. We say that they took into account irrelevant considerations in making the decision. And again, I hope everything that I've said this morning makes that clear. But to the extent that I have to motivate that, the irrelevant considerations which they have taken, the first one is the true reason, which is that you did not vacate of your own volition. That's completely irrelevant. There's no such thing in the legal framework about volition or non-volition. We've shown it with the reference to death. The second one relates to the manufactured reason that came later, which is the one about misconduct and incompetence. And as your lordship has correctly pointed out, that would bring into this case something completely irrelevant, which is the outcomes of the impeachment process. And the corollary of that is this: there is no moral stroke fault-based stroke turpitude-based qualification to the entitlement of the gratuity. To the extent that it is being introduced, smuggled into the legal framework, that is an irrelevant consideration. And that's clear because well, firstly, even if you look at the volition standard, that doesn't exist, or you look at what, let's call it the blemish, the new one.
But you've made submissions earlier on
yes,
this point.
Yes, but my lord, so I said when I started that when the submissions with regard to the first leg and this one's overlap. But it's my duty, my lord, if your lordship asks me if there's any other ground, to answer to that ground and then show how it relates to this case. I would have thought. Yeah.
Yes, no, yes. I have made a note.
Yes, okay. So I'm answering the question. I know your lordship didn't pose it, but the question is, if you say, you can't just say they've taken into account irrelevant considerations. I have to tell your lordship what those irrelevant considerations are, and that's what I'm busy doing. and those irrelevant considerations are the whole, I don't know to go chapter and verse, the whole thing about the lawyers' fees, this, that, and the other, and that's why I was summarizing it into saying morally based, or turpitude, or guilt, or fault, or whatever. I didn't want to spell them out specifically. Your Lordship knows what I'm talking about when I'm saying that they say without blemish, or you must show that you are a good behavior, or whatever. None of those things. Like the judges, the gratuity would be payable. Even the only adjective that's ever put to the payment of a gratuity in terms of a judge is active. So it says if you resign after active service. Again, active service simply means you were doing your job actively, not excellently, not without fault or whatever, not because your judgments, if you took judgments for 6 months or whatever, that's all that is. The issue is were you in active service. It's quite a neutral term. And in the same way, the Public Protector has shown in the papers that she achieved clean audits. She did all that was required of her, and she was actually, it was the first time any Public Protector had achieved those achievements. So here's the example, my Lord, which maybe might come home easily. Let's go to the judges again. I don't want to mention names, but let's say there's a judge who, for all intents and purposes, has excellent service and active service. In year 15, and all these years they've been accumulating the rights to the gratuity. And then in year 15, they drive into the yard of a house. Nothing to do with their excellent judicial career. And for that, one thing leads to another, and let's say they break, their eyes move out or whatever, and then they have incapacity to change the story a little bit. And then they are removed. Now, you can't say, well, that person, which is really what the case is, that judge must forfeit all the 14 years of accumulated gratuity of active service simply because they've now been removed for something. So that's what this Public Protector is saying. She's saying, I performed my duties to the extent that I was found to wanting by Parliament. It's common cause that is being challenged in separate proceedings. There's no debate about that. That may or may not be found in her favor. I don't want your Lordship to even entertain that. For the intents and purposes of your Lordship, it's 50-50. It will be decided in that court. But what she's saying is that irrespective of the findings and the political machinations that might have resulted in my impeachment, which is being challenged, I was in active service, quote unquote, for 7 years, 6 years, whatever it is. Factor E.
Forgive me, I don't follow the submissions in relation to the taking into account of irrelevant considerations, which is a third ground.
All right. Okay, let me break it down. It is irrelevant in our respectful submission that, forget about the judge for now, that Ms. Mkhwebane, let's concretize it. It is irrelevant that Advocate Mkhwebane, for the purposes of determining the eligibility or non-eligibility for a gratuity, as your Lordship said, whatever happened in the impeachment process is an irrelevant consideration, because there is no standard by which that which happened there, good or bad or indifferent, can be transported into the service conditions or the Section 2195 of the Constitution or the Basic Conditions of Employment Act. Let me put it simplistically. The Basic Conditions of Employment Act says when your contract has been terminated, you must be paid your remuneration within 7 days. Full stop. It doesn't say if it's terminated and you have killed 1 million people or whatever. There's no such qualification.
Right. So you are submitting, as I understand, that whatever happened in the Section 194 process has got nothing to do with the applicant's entitlement to a gratuity.
Legally speaking, yes. I'm saying there's nothing in law that entitles. In the case of a president, obviously, it has an impact. But in the case of a judge or a Chapter 9 institution, there's nothing in law that entitles you simply because you've been found guilty of this, that, right, or the other. Right. To be.
The point is noted.
Yes. So it's again. So it's either there is or there isn't. There either is something in law that says you may take into account how it is that you got removed.
And the case is that it shouldn't have been taken into account, and because it shouldn't have been taken into account, that renders it an irrelevant consideration.
Yes, and the point comes from the earlier point we made earlier, which was that the assume for argument's sake that the removal was for incapacity, for example.
Okay. Now, Mr. Mpofu, I understand the
yes,
point.
okay. If
there's another one, please make it.
Yes. Okay. So that's the ground of review. It's a well-known ground of review that if a decision is motivated by taking into account irrelevant considerations, then it must be set aside. Then, my Lord, we have made other issues about arbitrariness. I won't repeat. I've already said why we say the decision is arbitrary. We've also made suggestions about what we call passing the buck. There's a judge who said there's no such ground of review, but there is. The fancier word is called abdication, which means when you make a decision and then you say someone else must make it, which is what happened with the Parliament, the toing and froing between Parliament and the Public Protector. They were saying, no, it's your decision, no, it's your decision, no, it's your decision. That's from a innocent citizen's point of view, that is irrational by the state or any of its organs. It doesn't matter for present purposes. All the ones that are before you, at least the two that are before you here. And then, when it comes to both parties, but even more so with the Speaker, the Speaker didn't even make a pretense of giving a record. That's irrational. Well, not only is it irrational, it's just illegal. Yeah. And no pretense of giving any reasons. And they have a solemn duty as an organ of state to...
But you are not contending that the Speaker was a decision maker.
My Lord?
You are not contending, the applicant is not contending that the Speaker was a decision maker.
No.
Or does she?
She does. She does.
So then there were... then the decision maker then, would that be the officer as a juristic person, the public protector as the person holding office, and then the Speaker of the National Assembly? So then there will be three decision makers.
No, my Lord, please. That's not what we're saying. We are saying that the decision is made, okay, let me put it this way, it's made by the state, okay?
No,
Just bear with me. Just bear with me.
It's unusual to say that the state made a decision.
Yes. No, if Your Lordship, please bear with me. Okay, let's go to ground rules. Go to the heading. The reason why we've said Busisiwe Mkhwebane versus Office of the Public Protector, Kholeka Gcaleka, President of the Republic of South Africa, Minister of Finance, and the Speaker of the National Assembly, is because all those players, the reason why you cite those players, all 5 of them, including the Minister of Finance, is because you, as a citizen, what you're saying is that I am entitled to a gratuity. Any one of you, to the extent that a decision has now been said to me, who has any role to play in that decision, must give me reasons so that I can sue you, so that I can take you to court and give me a record. Right?
Well, I mean, you would sue other persons, rather, you would cite other persons in review proceedings, not because they are decision makers as such, but because they may have an interest. And that would be another basis for suit. But what is of moment is identifying the decision maker, which I thought you had done. But I now understand that the Speaker is also a decision maker.
No, my Lord. Honestly, if you go to page 0428, you'll see this comes from the notice of motion, which is really what I was busy with, the duty of the Speaker to give us reasons if she had any, and so on. We say that in terms of Rule 53(1)(b), alternatively Section 173 of the Constitution, in other words, if it doesn't fall within those review, the first, second respondents, and then in brackets, and or any other respondents who played any role in the impugned decision, are called upon to dispatch within 5 days after receipt of this notice of motion to the registrar the record and any outstanding reasons.
Right.
Okay?
The point is that the Speaker did not produce a record, and I understand that is one of the variables in the taking into account of irrelevant considerations.
No, it's a new.
That's something else.
Yeah, this is something else. I'm saying that the failure, the conduct in the failure to give reasons to a party that has requested you to do so is itself an indication of irrationality, because you are compelled to do so by at least the rules of court, if nothing else.
So which ground under legality review are you now canvassing in relation to the Speaker not having given a record?
It's the ground that is pleaded in the supplementary affidavit, which talks about this, which says that to the extent that the respondents failed, well, in terms of with this one, gave an incomplete record on our version and no reasons, and to the extent that the other one gave nothing at all, we say that is a breach. Illegality simply means that you've breached the law. It doesn't matter which law it is. Yeah. So we say that it's an act of illegality in its own right. The deprivation, by the way, is a deprivation not just of the applicant but of the court as well, of the full ambit of the case, so that it can be adjudicated. That was said in Helen Suzman case and so many other cases. The court might not think that's well, if the court doesn't feel inconvenienced, the applicant does by that conduct. Certainly. So in terms of that, either Audi as you generally know it, or Audi as it is described in procedural irrationality, and all the cases about that, the bias or reasonable perception of bias, and again, I don't need to the applicant has...
You've made those points, Mr.
Yes.
Mr. Mpofu.
Yeah, and the third one is fourth one, relevant or irrelevant considerations, and the fifth one is the failure to conform with the requirements of Rule 53. Sorry, my lord. And your lordship knows that there is, we say and I said this earlier, the decision is also irrational to the extent that it is in breach of the BCEA and or the rule of law. You'll find that at page 02185. And you read that with the supplementary affidavit. So, my lord, as far as costs are concerned, again, I won't repeat the submissions, but it should follow that, and as I say, your lordship can read between the lines, for example, between the lines as to some of the conduct which has already attracted punitive costs. But even since then, because unlike them, we don't want a double punishment. Even since then, it's our submission, or even before then, for that matter, it's our submission that even before the institution of the proceedings, the conduct, and I don't need to take your lordship through chapter and verse, the conduct of the proceedings, and even the inclusion of all these, not to mention the mentioning of legal practitioners by their names and how much they earned and so on, all of which has nothing to do with the issues here. It's just pure vindictiveness and malice, really. That all of that whole basket of issues, which your lordship has already said do not feature here, is itself an indication of conduct which your lordship hopefully will discourage other organs of state from doing, because they don't have to. An organ of state should not be combative about this, my lord, and that's the point we make really at the beginning. We say that if the organ of state was genuine about not knowing what the law is, which happens to many organs of state.
The applicant seeks a cost order to be made against the person of the second respondent. Can you make submissions on that?
Yes, my lord. Yes, thank you, my lord. Yes. But maybe all that can be subsumed in what I'm about to say. If you look at paragraph 12 of the notice of the founding affidavit, we say, my lord, given the fact that the first and second respondent seemingly and mistakenly believed that there was no enabling provisions empowering the payment of the gratuity, an incorrect view stemming from the failure properly to interpret the relevant constitutional and other provisions, but we forgive them for that. We say it is not anticipated that they will oppose this application, which is intended to give clarity on that very question. However, and in the event of opposition, then a punitive order, of course, will be sought on the grounds that the failure to pay will not have been born out of a genuine misinterpretation of the law, but suspected vindictiveness and malice, which has no place in the public administration. Let me unpack that, because that's the same submission with the personal cost. So we're saying, here's a party that says, my lord, as they're entitled to, we don't know where the duty lies. We're saying, if that was true, and they really saying, look, we don't have, then we're saying, here we come to court, we get a court order. That's where the obligation will come from, at least, if nothing else. So, but by coming out guns blazing and making up new reasons and manufacturing the law and so on and so on. For what? What do they gain by Advocate Mkhwebane not getting her gratuity like the public protector, current one, is going to get, hopefully, when either she resigns or vacates the office for whatever reason? What do they get by singling her out from all the other public protectors since 1994 who have been paid their gratuity? Except the hateful intention and vindictive.
No, Mr. Mpofu, that's not entirely correct. They say that the applicant is the first ever public protector to have been taken through the Section 194 process,
Yes.
that certain findings were made about her, and that for that reason and others, it is not a surprise that she, unlike other past public protectors, is not due a gratuity. They gave an explanation. The applicant, of course, differs from the explanation given, but there is an explanation.
Oh, my Lord, I'm sorry. The law doesn't say you must have an explanation. You must have an explanation that makes sense. So you can't have an explanation that itself is the product of lies, because we've established that that version is the version that only comes in the answering affidavit. We've established that the version that Your Lordship has just repeated now could not have been the reason in terms of the letter, because the letter says nothing about findings. It says nothing about all the things Your Lordship is telling me. The real reason, which was cited in the letter of the 12th, does not have the things that Your Lordship is telling me. So how can you say they have given an explanation when that explanation itself is quite plainly contrived and manufactured? So an explanation, I'm sorry, doesn't hold it. It must be an explanation that makes sense, and an explanation that a court of law can...
Forgive me, the court does accept that the applicant no doubt differs with what the respondents are saying.
No.
But for what it's worth, they've put up a version to the court, and the applicant has dealt with that version, and the court will make a determination on reflection.
Okay, well, I have to say this at least. If in any court at least, or even in a disciplinary hearing, if somebody, they say, why did you do this? Why did you beat up the other employee? And then you say, it was self-defense. Then they show that it was not self-defense. Then later you have another explanation and another explanation, another explanation. All I'm saying is that by the time you give your explanation number 30, it can't be that a court can then say, now finally we found one that we like. And the explanation itself in a court of law, that's why we're here, it must have credibility.
Yes, Mr. Mpofu, yeah. I understand your case. Yes. Your case is...
that there's no explanation.
That your case is that what has been said in the answering affidavit, insofar as why the applicant is not due a gratuity, is an after-the-fact rationalization, because that's not what she was told when she was given the letter. So you've made that point.
Yes, that's the first issue, madam. The second issue is that assume now that in the letter they had made all those points. In other words, there's no ex post facto rationalization. I'm saying, as Your Lordship said to me 30 minutes ago, that that explanation, there is nowhere in the law which says you must, if a public protector or a judge or any other official has been found guilty of mass murder, they must forfeit their remuneration. So I'm saying, even forget about the ex post facto thing now. I'm saying in any event, that explanation doesn't hold any water because it has no place in the scheme.
But you've already made that submission at length.
Well, my lord, then you must not ask me to comment on their defense if you don't want me to address it. You've said to me their defense is that the reason, good or bad or whatever, is that she was found guilty of certain things.
No, Mr. Mpofu, that's not what that wasn't the exchange. The exchange was you were submitting to the effect that there was no explanation, and the court said they do put up a version on paper, and the court then indicated to you that you've made submissions that the applicant takes issue with the explanation because what is set out in the papers is not what she was told. Yes. So the court is not inviting you to recite the submissions made earlier.
Well, okay. Well, the court, I'm afraid, I don't know, maybe we can play the record. I've never said that they don't have an explanation. I've never said such a thing. They have an explanation. I'm busy making submissions to the court to show that that explanation does not hold any water. How could I? Anyone who has read these papers will know that they rely on what I call the fault-based, all the things.
And you have made that point already.
Yes. So and I have to address this because it has been raised with me, and I'm saying that even if you look at it benevolently and say that they have made that explanation, it is, on the words of your lordship, one that has nothing to do with the case before us, and certainly has nothing to do with the legal framework. Now, that cuts two things. It cuts the issue on the issue of bias, vindictiveness, and all that, but it also cuts on the issue of costs, and on the issue of personal costs in particular, because clearly, from the evolution of this matter, starting from March, we've given you blow by blow as to what happened when the legal representation was withdrawn, and so on and so on, right up to today, literally, of the continuum of conduct on the part of the second respondent as the purveyor, if you like, of the vindictiveness and malice and all the things that we allege, and making up of reasons and so on, everything I've said before. And for those reasons, my lord, and because of what was said in the case of South African Reserve Bank versus Public Protector, which incidentally, one of the reasons why personal costs were given to the public against the Public Protector there was non-compliance with Rule 53, which is exactly what I was trying to explain here earlier. But for all those reasons, both punitive and personal costs are called for. My lord, if I can just, what is it? Yes. Just give you, I won't even motivate, I'll just give you this reference. Siriti and another versus JSC, 2023, bracket 5, SA 304 GJ.
Right.
That's the case that deals with what we discussed in the morning, my lord, about the congruity between the charges, the remuneration, the gratuity, as it applies to charges and as it applies here. My lord, well, we do have on the other alternatives. I want to address them. We do have other submissions. We'll cover whatever comes from the other side in reply. Sorry, my lord. Which answer? I'm sorry, I'm already sorry. Page? Yes. Okay. Malena, I have to trust my junior that this deals with the issue of empowering provisions, and I think it also deals with irrelevant considerations. Paragraph 65 of the answering affidavit of Ms. Gcaleka say the applicant alleges that the decision maker took into account irrelevant considerations, in particular the fact that the applicant had not vacated office of her own volition. I have explained above why this fact was highly relevant to the decision. It is a relevant consideration because conditions of service distinguish between situations where the public protector vacates office at the expiry of the term and when they are removed from office. In the applications of the conditions of services, this was therefore an important fact. Yes. So that's the version, which is based on the empowering provision of the service conditions for the case of Ms. Gcaleka. Let's go, please.
Yes. Thank you, Mr. Pofu.
Thank you,
yes. Mr. Mkhwebane.
I want to propose that we adjourn, and that is 15:52. It's 8 minutes before 4. I can start at 10.
It's been an extended 2 hours.
It has been. I've been here before, but could I just propose that the most practical thing is to adjourn and resume at 10 o'clock tomorrow?
Yes. Well, the court can sit earlier if the party says suitable.
I've asked Mr. Mutao about 9:30. I haven't asked Mr. Pofu because
yes.
he was on his feet. And Mr. Mutao, what was your answer?
Perhaps the court doesn't want to know. We'll sit at 10 then. If
10 well, my lord, let's take 10 o'clock. Let's see. We might try and assist your lordship by focusing the arguments. But I don't want to make commitments that my attorneys would disagree with. But the afternoon might help us. But let's not blame anyone. There's a lot of blame that's been passing around today. Thank you, madam.
Yes. Mr. Mpofu?
Yes, madam. As a court business. My lord, well, Mr. Mwatobi is already in the back. If Mr. Mutao has no objection, I would propose that we start at 9:30, madam. Your lordship has already said your lordship has no problem with that.
Yes.
So that also we because the danger is that if that doesn't happen, then we might need that half an hour at the end. Rather, it's always easier to do it at the beginning.
Yes.
So in the morning while everyone is still fresh.
Hear what Mr. Mutao has to say.
No, I know what it is.
Well, I'm entirely in your hands.
Yes. Well, then my hands say that the court will sit at 9:30.
As court business.
The court will rise.